May I please, Your Lordship? Pardon to mention item 5 supplemental list. Paper adjournment 1 week due to Mr. Amitabh Tripathi sir suffering from dengue malady disease.
Nine. After lunch. To be adjourned. Okay. There is a defect learned council. We are adjourning the matter.
My lord.
We are adjourning the matter, Mr. Tripathi's matter.
Yes, my lord.
But you remove the defect by the next date.
Yes, oblige.
That the matter will be listed on 5th September 2023.
Oblige, ma'am.
That we request made for Mr. Amitabh Tripathi and council appearing to be appellant. Meanwhile, the defects be cured. Yes. Next.
Item 11, Your Lordship. Last occasion, Your Lordship directed to file an affidavit. I will file in course of the day, Your Lordship, may be taken up next week.
List on 5th at the request of Mr. N. Lankal and council appearing for litigation. Next.
Page 3, item 15 to 20. Page 4,
Item 20, Your Lordship.
20.
I will file the certified copy, my lord. Your Lordship may call it next week. The defect.
You have filed already?
I filing today.
All right, let the matter be listed on 31st of August.
Hello.
Mr. S.K. Saragil and senior counsel has asked for the short accommodation for filing the certified copy. Is the precedence allowed, but the certificate copy shall be filed by the next date invariably. Yes.
page number 4, item 21 to 25.
My lords, item 21, lords. I humbly pray for a short accommodation, lords. I appeared for opposite parties. Lords, Mr. Sarangi is in disposal, my lords. He won't be available for the argument today.
Mr. Sarangi is going to argue the matter?
Yes, my lords.
Okay.
In fact, my lords, we have taken consent.
Have you talked to Mr.
Yes, my lords.
Senior Standing Counsel?
In fact, he is also suffering from dengue.
Okay.
So, if my lords pleases.
Let the matter be listed 13th of September 2023 as request made for Mr. S.P. Sarangil and counsel appearing for the opposite party. It has been stated that when a senior standing counsel appearing for the commercial tax has been informed.
My lords.
Yes.
There are
Page
4 matters.
Same order in the matters.
Page 5, item 26 to 31.
Your Lordship, item 26. On behalf of Dr. Lenka, Your Lordship, Dr. Lenka's sister is hospitalized. Kindly any other date, Your Lordship.
You tell them.
Item 26.
26, Your Lordship. Dr. Lenka's sister is hospitalized, Your Lordship. He is not available today.
Whose sister is
Dr. Lenka, Your Lordship. Rekha Lenka.
it has been stated that Dr. J.K. Lanka is indisposed of list the matter on 13/9/2023. Inform the counsel of the other side. The counsel for the respondents be informed. Yes.
Page 6, item 32. Page 7, item 33 to 35.
That's item number 34, 35, 37, and 38 minutes. Similar matters have been posted to 5th of September minutes.
Yes, number
34, 35, 36, 37, 38. All these are outsourcing matters. So last fixed it to 5th September.
a list on 5th September when the other analogous matters are listed.
Grateful minutes.
Page 8, item 36, 39 and 40.
36, 37, 38.
37, $30.
37, 38.
Also.
Page 9, item 41 to 44. Page 10, item 45 to 48. Page 11, item 49 and 50.
May I permit to mention, my lord? It's out of list. My lord, this is the habeas corpus, the minor daughter of the petitioner. Shall we
double-headed 2022, madam. In person, I have filed WPC number 21376/14, which has been dismissed during the year of October 8/21. I am submitting a memo for restoration of the dismissed case.
My memo will not restore this matter. You file a proper application.
I have filed CMPL.
You have
I have
filed.
filed already CMPL case.
Okay. Take up this matter day after tomorrow. Come day after tomorrow.
Take permission from my lords to make a prayer, my lord.
Yes.
My lord, one matter to be specially assigned to honorable single judge other than court number 22. It's a little amount of urgency is involved there. Can I just make a prayer? Unless it is placed before my lords, it will not be assigned. So the DR has to place the matter before my lords to assign it to a particular bench.
Now, matter has been listed some other bench.
It was listed in honorable court number 22. Honorable court number 22 recused from hearing the matter.
So that's the order is there. Just to give a short sheet. That on the administrative side.
Pardon me, mention my lord. Writ appeal number 888/2022, my lord. Wants to an infructuous, my lord.
Infructuous?
Yes,
File the memo.
My lord.
It is not on list today, I think.
Yes, my lord.
It is
Today,
on, not on list.
not this, my lord.
List it tomorrow.
List it, my lord. Oh, bless, my lord.
I may pardon, my lord. Some fresh writ appeals. And one writ appeal, I pray that let me be listed prior to 17, my lord.
List your matters on 14th August. Give the list.
Yes, this matter prior to 17 is 13. Other matters in the.
How is it?
Yes. Supplemental list, fresh admission number 1.
May I please, your lordship?
Yes.
Lordship, may kindly refer to order number 2, dated 25th of January 2023, your lordship.
Yes.
At the request of learned counsel appearing for the parties and awaiting decision in the batch writ appeals, using WA number 234/2020,
Yes.
the bearing appeal is likely to be listed on 9th of August 2023.
Yes.
That is the order, your lordship. What has happened? In this batch of matters, the judgment was reserved, but because of the difference of opinion, the matter was referred to a third judge, your lordship. And unfortunately, the same has not been listed till date for the third judge.
This in 2021 matter has not been listed so far.
No, your lordship. Well, there was a split verdict.
I understand.
It has not been referred to the third.
21 matters we are on 2023.
Yes, your lordship.
Okay, I will pass the order in the administrative side.
My lordship.
Yes.
It's a similar matter. It has been tied along with this matter, your lordship.
All right. But there will be some problem because in this matter there is no judgment. I would suggest you wait till the decision is given by the judge who will be referred to, because that will cover their judgment then. Whatever the way it is decided now, because it was not heard, it was not earlier part of that batch.
I beg apology for barging up in your lordship, but there is also a judgment referring to that. It's also a writ appeal. In this writ appeal, also we are challenging the order of honorable single judge, but referring to the batch of writ applications which are disposed of by the single judge, that has been passed the same order. So it has to be connected, your lordship. The impugned judgment is at Annexure 10, page number 58.
You are not getting my point, Mr. Biswal, that The other matter, there was an effort of writing the judgment, but there was no consensus.
My
So
lord.
there was a split judgment. It is supposed to refer to a third judge now,
I do understand, your lordship.
right?
I do
So,
understand.
but this was not the.
Yes, your
How
lordship.
do you
Yes, your lordship. Yes, your lordship.
whatever way that will cover, whatever way it is decided
Yes, your lordship.
already. You give that, this list you have taken it, okay? Just call this judicial, list of judicial to bring it, huh? Just send it to you. Okay.
Much obliged, your lordship.
So what we should do this matter? We fix this matter sometime in third week of September. Let us see what happens.
My lordship. As your lordship pleases.
27th of September, it has been pointed out that in similar matter, there is a split judgment. So as a matter of rule, those matters which are identical to the present appeal are to be referred to a third judge for decision. All right.
Item number 2. May I please, Your Lordship?
Yes.
In this writ appeal, Your Lordships, the appellants have challenged the impugn order as paid 81 and 82. May I
Yes.
be allowed to state the brief facts?
Yes. Come.
The appellants are
You are challenging this order dated 3/9/2021. Which order you are challenging?
6/7/2021.
Annexure
It is
9.
81.
Annexure 9.
Annexure 9, Your Lordship.
Okay.
Order of the Honorable Single Judge, Your Lordship. There, the Honorable Single Judge has rejected my petition on the ground that the petitioner were not having the requisite qualification as per the advertisement, Your Lordships. The petitioners, the appellants have done the Hindi language Pandit training course from Andhra Pradesh, from the state of Andhra Pradesh. It is recognized by NCT, Your Lordships.
And what is the required qualification?
As per the
Advertisement.
counter of this, the
As
government,
per the advertisement.
as per the advertisement, they should have possessed the equivalency certificate at the time of this apply of that application, Your Lordship, filling of that applications.
Do you have annexed this advertisement?
Lordships. The advertisement is annexure 1, Your Lordship, page 32.
Page 32. Come to page 32.
And the qualification is prescribed under para F, page 34, Your Lordships, in the teachers.
Yes. What is your bachelor's degree certificate?
That is not disputed, Your Lordships. Only on the ground of equivalency certificate, the petitioner's candidature has been rejected, Your Lordship. And
All right.
they have rejected the application of the petitioners on the ground of equivalency certificate. And they have mentioned in all the other points are not disputed. Only the equivalency certificate is disputed, Your Lordship. Their counter also, the state has only taken that ground that the petitioners are not having the equivalency certificate at the time of that application, Your Lordships.
You had later on you have filed the equivalency certificate.
Later in Your Lordships, at that time, Your Lordship, the Sambalpur University denied to issue equivalency certificate to individuals. Subsequently, the Utkal University has granted, in my reply to the affidavit filed by the government, kindly have a glance to the annexure 12, Your Lordship, page 6, reply to their affidavit. In their affidavit, they have only stated that due to their not requisite qualification or equivalency certificate.
What is their affidavit? Page. Where is the counter of it? Will you annex it?
Annexed at page 67, Your Lordship.
All right.
The relevant pleading is at page 69, paragraph 8 and 9.
Eight and nine.
Your Lordship.
And in the writ petition, you come where it is stated that this is an equivalent qualification of the graduation.
Your Lordship, in the writ, firstly, I filed an OA before the Orissa Administrative Tribunal also.
Come to this writ petition means original applications, come to that.
It was a transferred brief, Your Lordships.
I understand that has
Lordship.
been treated as a writ petition now, just come to that. Where have you stated so?
In my OA, Your Lordship,
Yes.
may I ask? May I read para 6.16, page 28, Your Lordships.
There is nothing like the equivalency statement, just come.
Therefore, once the NCT is accepted such certificate to be equivalent and the state of Andhra Pradesh has also accepted the same to be equivalent and read in Hindi, there is absolutely no decision on the part of the state government to eliminate the applicants for consideration solely on the ground that the applicant is not eligible. Rather, the NCT recognition being a central legislation is binding on the state authority insofar the qualification in Hindi is concerned. The state
NCT regarding the graduation degree doesn't have any status to determine this.
Beg pardon.
NCT relates only to the schools. Sorry. So where the graduation program is concerned, it is not-
NCT it teachers training course here. This is the B.Ed course, Your Lords. For the schools, Your Lords. Mean for schools.
this is you are, but your Hindi, they says that you do not have the graduation in Hindi. They do have the graduation in Hindi.
I have the graduation. They are saying that the professional course, the B.Ed course is not equivalent to the course as required for the state government. Kindly have a glance to their counter at page 4, Your Lordships. Affidavit filed by them, the page 4. May I read, Your Lordship?
You first come to the finding of the learned single judge that I have read in Annexure 6. Sorry, it's not Annexure 6, it is Annexure 9. Just see, it is the first, the second, the paragraph at the bottom of that order, page 81.
Lordship.
Since the course of the Hindi language Pandit training, which is the petitioners have acquired, has not been mentioned in clause 3.7, their application has not been taken into consideration.
Exactly, that my
I am
humble
not
submission.
coming for the training. I am considering the basic qualification of Hindi graduate is questioned by the learned single judge.
No.
What you are saying now, read this again.
It is contained that the course Hindi language should be treated as the equivalent.
This is a submission. The observation is that since the course of Hindi language Pandit training, which is the petitioner have acquired, has not been mentioned in the clause 3.7, their application have not been taken into consideration.
Exactly, Your Lordship. May I read? The government has also stated that their course is not mentioned in the advertisement.
Yes.
The only mention is that, may I read the
Yes, equivalent qualification.
equivalent, Your Lordship.
So, but you are going for the teacher's training. I am asking you basic qualification, graduation in Hindi.
Any bachelor's degree with the teacher's qualification.
But first, this conform to the bachelor's degree.
Lordships, they are having the bachelor's. Only one petitioner was not having.
This is
He
the-
has not been a made party in the writ petition. only one petition, that is not disputed, your lordship. All those have done their bachelor's degree. Thereafter, they have done their.
But what is this observation then?
That has wrongly been mentioned as because only.
Show me that how you have acquired the bachelor's degree.
Bachelor's degree, your lordship. Kindly have a glance. After the bachelor's degree, they have to pursue this B.Ed degree, your lordship.
Where is the bachelor's degree? Come straight to the bachelor's degree. They say that you have done some course in the RATHO like that. That is, according to them, is not equivalent to the bachelor's degree.
No, no, your, may I
just come to that point first, Mr. Counsel.
That as the bachelor's degree was not disputed, your lordship, I had not filed that. Only I filed the
not
technical.
disputed, learned single judge, and you don't have that basic qualification.
Because that was a misunderstanding. Because of that, your lordship, only opposite.
You show from the record that is an incorrect finding.
Because your lordships, when the course is, the B.Ed course can be pursued after the graduation.
No presumption. Sorry, no presumption regarding basic qualification. Either you have the qualification with certificate or that, or you don't have this qualification.
At the time of filing that OA, your lordship.
Submission come to the document.
May I please hear? At the time of filing that OA, your lordship, I did not file all those BA documents as because, your lordships, the dispute was only regarding the education, technical education pursuant.
Now, if you want to say that the single judge's observation is incorrect, you have to show from the basic documents.
As because, your lordship, I did not get any opportunity to clarify on that point, your lordship. Only opposite.
You only heard.
Your lordships, unfortunately, on that day I was absent due to some personal difficulty, so I could not.
Already you are adjourning the matter on 31st of August. You file an application with leave to file the document. We'll consider their
graduation certificate, your lordship. I will file.
Consider, because this is an observation by the learned single judge.
Just on the basis of the
useless to make further submission.
Lordship.
At the request of Mr. D.K. Saul and Counsel appearing for the. You are there. Your name is there, Mr. Sahu.
I am not Sahu, your lordship.
What is your name?
Amitabh Pradhan.
Oh, sorry. But some counsel was there. According to the order.
I was the conducting counsel. He was just.
Don't say these things. You are conducting someone who is representing the petitioner. Mr. Pradhan. Let the matter be listed on 31st of August 2023. We give the appellant liberty to file the appropriate affidavit with the documents he wants to rely on in support of the basic qualification required for appointment as in the teacher. You are Mr. Jena?
Behra, Arnav Behra.
Mr. A. Behra, you are a standing counsel?
Yes, additional standing counsel.
Additional standing counsel appears for the respondents. This is the first thing first. I am just asking them and give the opportunity. Okay. Yes.
Item number 3.
This is last on 14.3 on which date my lord wanted that you have to explain whether such appeal is maintainable or not. So far as mentality is concerned, I'll only point out one thing for my lord's kind appreciation. Had it been adjudicated on merit, I would have no case. But it has been dismissed. That why it was not listed earlier, that I am not entertaining your claim. That is the imposed order. My lord, kindly see page 13. At page 15 or
yes.
Since it was not listed, my lord is conscious that up to March 28, February 22, COVID was going on. Many things changed. Entire scenario of this honorable court changed. Filing of memo, we are also confused. In what manner those will be filed? whether in hybrid mode or in,
Forget about all these things.
no, I pray that it has not been adjudicated. Had it been adjudicated,
No, come and read the order dated 25th of February 2022. That is at page 15.
including order of the honorable single judge.
Yes. Page of your paper book 15.
The impure order which you are saying there was no adjudication and the CMP was dismissed. That order, please place it.
This is the order that you have challenged in this.
No, that in my file. Into that.
Challenge the order and
Today morning I read it. The order time I challenge
So you are not ready with the case?
I'm ready. Yes, I'm missing from my file. That is why today I read it. Only in the middle, your lordship will say that since it was not listed earlier, we are not going to entertain because by keeping it pending, it will give rise to delay in the process of adjudicating in many
Come
cases.
to the order. This is the problem when you just speak something from your mind and it is not telling me the records. It's very difficult to accept such
Today, when I was going to the brief,
just read where
I got
it. Yes, just read.
this civil miscellaneous petition is filed in the year 2020, challenging the order dated 10/12/19, passed by the Land Civil Judge Junior Division, Windsor, involving rejection of the application under Order 6, Civil 17 CPC in CS1 156/2012. 2 years have already passed from the date of order and the civil miscellaneous petition is not moved. Issuing notice after such lapse of time not only linger disposal of this suit, but will seriously prejudice the parties otherwise. So they are not entertaining.
No, you have not moved the application. You have not moved the application means what? Means what within that 2 years, the suit
Understand?
2 years the suit has moved forward.
Everything was installed during that time.
No, it's stalled. It is a stall. All right. Now come to the order that you have challenged. Where is that order? That order of the passed in the civil suit. Where is that order?
That order I have annexed in the CMP.
Where is that CMP?
CMP is 153.
Where is that with this appeal?
If your lordship will go through the CMP record which I have filed, in that I have annexed the order of the court below. That is annexure 5 in the CMP. In which
What is the date of the order?
10/12/19. In that order, court says that it will change the nature and character of the suit. That is why we are not inclined to allow your amendment. Amendment was only to change certain khata number and plot number which was inadvertently by mistake wrongly given. That was it is not going to change the nature and character of the suit. Nature and character of the suit is that it is simply suit for injunction, that you are not permitted to come to my land because it is my land. Nothing has been paid by you for alienation. So you cannot claim any right over this property. So you have to be injuncted. That was my suit.
What is the part that what is the amendment of the schedule amendment in the petition?
My petition is
Annexure 3.
page 25 of CMP.
All right, what is the schedule of amendment? What do you want to say? You have not identified.
Yes, I have given schedule.
What is that? Page
Your Lordship, going to that
yes, page 30. Come to
page.
You are substituting a land, not adding. You are saying
You are
Substituting.
You are
Delete the wrong number.
no,
Add this.
no. Sorry. You are just completely changing the
Madam.
description of the land.
We are Adivasi people. We are illiterate
the
persons.
advocate.
To brief our client, there was a mistake. We have given a wrong number. That is my pleading. That is why I may be excused. I may be permitted because it will give rise to multiplicity of suit. If I fail in this suit, I will have to bring another suit. So to avoid that, I wanted an amendment saying that this khata number, plot number.
Still appearing for the appellant issue notice. Issue pre-admission. The returnable on 22nd of September 2023. Steps for service be taken. Registered posted with AD within 3 days from today. All right. Mr. Sinha, let other party come. All right.
I take out notice.
3 days.
All right.
Item number 4.
May I please, Your Lordship? May I
Yes.
please? Pursuant to an advertisement dated 28/8/2021, the appellant applied for the contractual TGT post, Your Lordship. Each candidature was rejected for overage, pursuant to which he has filed a read petition before this honorable court.
Yes.
And in that read petition, there was an order that he has secured less mark than the cutoff mark. Therefore, the read petition has been dismissed, Your Lordship. Against that read petition, the present appellant has filed this read appeal. Your Lordship.
Stated that you have secured marks more than the cutoff mark.
Your Lordship, for that reason only my read petition was dismissed.
No, read petition says that he got less mark than the cutoff mark.
Your Lordship.
Your contention that you secured the higher marks than the cutoff mark? Higher mark than this cutoff mark.
No, my contention is that I have secured more mark than the qualifying mark as per the advertisement, Your Lordship.
No, that is not the issue. Cutoff marks is fixed during the screening process.
Beside this, Your Lordship, other candidate who have secured less than the cutoff mark as well as the qualifying mark, they have got appointment, Your Lordship. Following that,
Have you made them the parties in this litigation?
No, I have not made them the party, but
So
they were.
you are not entitled to make any plea against the persons not in the proceeding. Yes, no, this is not a matter of illustration. You're coming to the Constitutional Court and the Court of Records. When you place such records and see the illegality has been committed by the state, we cannot just sit as a mute spectator. So make them a party, otherwise lit petition is not entertained. You are making allegations against someone, sorry. This can be done in a constitutional process.
They were before this honorable court, those people, those candidates who have got appointment, securing less mark than the cutoff as well as they were before this honorable court.
For what purpose? They were selected.
They were not selected for overruns. Their matter has been decided in a case decided with this honorable court in Bhavita Satpathy case, and in the light of that case, they have got appointment, Your Lordship.
Were they overage or they were not
Overage as well as they have secured less mark than the cutoff mark as well as the qualifying mark.
All right, show us where you have been mentioned, because I don't allow this.
Copy has not been served on us, so we
serve copy because your appeal is also a delayed appeal. You did not file an application also, I think.
application is there. But if you don't serve copy, how will they assist the court?
No, copy has already been served, Your Lordship. In fact, I have already served the additional affidavit which I have filed subsequently. I have got the receipt, Your Lordship.
No, additional affidavit, you have the receipt. Appeal, do you have the receipt?
Yes, Your Lordship. Here.
Then show it to him, he'll get his file.
I will serve another copy. This is of additional affidavit. I will serve him another copy. And Your Lordship.
Condonation of delay also.
Your Lordship. And there are vacancy existing.
Do it fast. Serve copy fast.
Can it be taken up day after tomorrow in the today?
We are fixing the matter on 31st of August. Supply the copies. You are there on record.
Your Lordship.
You are not.
I have filed my Wakalatnama on 4th and my name has been reflected. Little mistake is there. It is Sunita Biswal, whereas my name is Sonita Biswal. So,
All right. Sunita Biswal.
Maybe it's
Reflect.
Oh. SONITA.
Your Lordship.
Such and such. Let the matter be listed on 31st August 2023. Meanwhile, copy of the memorandum of appeal along with the interlocutory application seeking condonation and delay be furnished to the State Council. All right.
Obliged, Your Lordship.
I will just give a serious thought to the issue that I have raised. You will not be allowed to permit to plead against anyone who is not before the proceeding. Even because ultimately their status will be affected if you pass any order.
As Your Lordship.
Yes.
Item number 6.
My lord, in this case, I am appearing for the opposite respondents, my lord. Except a leave salary, nothing has been paid. Retirement benefits I am not getting for last 8 years. Only after lordship direction, they have yesterday paid the leave salary.
6 number.
Yes, my lord. They have undertaken to pay.
This
Your Lordship, that I have given that instruction. Lordship. Next page.
This is from a vigilance case.
Yes, ma'am. No, ma'am, not a vigilance.
Okay.
So far as post-retrial dues are concerned, you'll have seen that we have taken steps for release of the same.
I am acquitted in lower court as well in appellate court, my lord. So nothing is pending against me.
Yes.
Yes. Both the court.
So far as pensionary benefits are concerned,
How can it be a revision filed by the government? I can't understand.
And after 1.5 years, 2
only
years
on the
have been
part of
passed.
the interest, my lord. Because so far as pension and other post-retrial dues are concerned, he is entitled for the same. But so far as only in the read appeal that interest part is concerned, whether he is entitled to interest or not.
Yes.
That is only to be decided here, my lord.
So, Mr. Mishra, what we do, as they admit this other part, they will release, let them release it without the interest part.
Yes.
We have released, my lord. We have released.
Already released.
So, your lord, see that
No, he's denying it that you have
he to
released it.
get, my lord, within 1 or 2 days he may get because
Obviously that means he has not.
yes, my lord, yes.
All right.
Have you instructed to release?
And Mr. Mishra, there is this miscellaneous application regarding condonation of delay, and delay is very small.
I have no objection.
Yes, it is about 242 days delay.
I have no objection.
Then we condone that delay.
Yes, my lord. Lord, I am entitled for retirement benefits. I am seeking
All right.
for retirement benefits.
You must be very happy. You must be very happy that Mr. Kunti has taken the stand.
But insofar as interest is concerned, I will take the same matter, I will contest.
2355 of 2023. Heard Mr. L.M.K. Kunti. Plantation Council, Plantation Government Advocate appearing for the applicants. This is an application under Section 5 of the Limitation Act for condoning the delay of 242 days and preferring the appeal against the order dated in the cost title. There is no reference of the
The order dated 5/8/2023
delivered in WPC number 16693 of 2022 by the learned judge. Mr. KP Misra and Senior Counsel, who is assisting you, Mr. Misra, today?
My lord, associate is there, my lord.
I am there. I am here, my lord.
Your good name, sir?
Neeraj Kumar Singh.
Issued by Mr. Neeraj Kumar Singh, has appeared for the sole opposite party and stated that the opposite party doesn't have any objection if the said delay is condoned. We have also perused the causes that has been assigned by the applicant. So, in view of the concession and the explanation that has been provided in the application, the said delay stand condoned, and the result, this application is allowed. Now go to the writ appeal. Heard, Mr. In view of the order passed today in such and such application, this appeal has been taken up for consideration. Heard, Mr. Kuntia, for an additional government advocate appearing to the appellant, admit the appeal to be heard on merit, issue notice returnable on 22nd of September. Stop. Since Mr. Kuntia, Mr. Planet, additional government advocate has stated that all retail benefits of the respondent shall be released within a period of 7 days, except the part of interest. We do not pass any other order. But such payment shall be made within 7 days from today. Mr. Singh Counsel, since is appeal for the sole respondent, no formal notice is called for. Stop. There shall be an attempt to hear the matter finally on the next date.
Next one.
Item number 7.
It is on record. Yeah, we are keeping it on record.
Yes, please.
Hello, sir. This writ appeal arises out of an order passed by the learned single judge under Annexure 11. And my lord, to recall that order under Annexure 17, my lord.
That order has been recalled.
No, my lord. It was rejected.
Oh, you wanted to?
I have only taken a ground in the petition for recall that for the self-same cause of action, a suit is filed challenging the letter issued by the Bhubaneswar Municipal Corporation, for which the direction issued to implement that letter will, my lord, dispose of the entire suit. Here is the case, my lord, under Annexure 1. The landowner has got the permission from the Bhubaneswar Development Authority. My lord, the plan was approved under Annexure 1. Your lordship will kindly come to Annexure 1 at page 15, my lord.
Annexure 1.
Annexure 1, page 15.
You are challenging now the 17 order in this appeal.
In this appeal, my lord, I am challenging the order dated 30/3/2022 under Annexure 11 and rejecting my application to recall that order, that is, my lord, 30/3/2022 under Annexure 17. My lord.
Yes.
Here is the case, fact of the case is that the landowner have applied to Bhubaneswar Development Authority for approval of the plan, which was approved under Annexure 1, my lord. The approval order shows that some vacant open space will be there for construction of a park, my lord. Thereafter, the landowner has my lord, gifted the land to the Bhubaneswar Development Authority for, my lord, construction of a park, that will be remain as open space. Thereafter, the petitioner society have purchased plots and constructed their house. And on the open space, a park was constructed by the Bhubaneswar Municipal Corporation, spending 78 lakhs, my lord.
Okay.
At that moment of time, the opposite party number, my lord, that is private opposite party number,
Anyone is appealing to the Bhubaneswar Municipal Corporation?
1 and 2.
In this matter, I am appealing for the respondent 1 and 2 by filing a caveat application.
All right.
Let him submit, thereafter if lordship require, right?
We'll hear the matter on merit.
My lord.
Mr. Monti also.
My lord.
Take note if you want instruction further.
Yes, ma'am.
Then we can just adjourn the matter for a few days.
Yes.
We'll hear on merit.
Yes.
Right? No notice, no stay. We'll hear the matter.
No stay, pretty good stay, my lord. Status quo order.
Pressing the material tax by I will satisfy with 1 minute.
It is a very small issue.
Small issue. That is why I'm telling you.
Road is to, they want that the
Can the road?
All right, we'll hear you on merit.
road has been constructed. Everything.
No.
Yes, everything.
Yes, my lord.
No.
Yes, Mr. Monti.
EMC said that I am saying this thing.
Have patience. This is
Yes.
not the way. Don't cross swords among yourself.
Right.
We are fixing the matter on 8.
My lord.
It will
There
be
are
hard on
very
8.
grateful.
Come.
Lots of do that.
Yes. All right.
My.
Till that date, my lord, your lordship.
Nothing would happen. 18th is a very short time. Is this matter on 18th August 2023? Since all the parties are represented by the council, this matter will be hard on merit at this stage. Stop such restriction of the council.
My lord, may I pray, my lord, it will come on face admission.
Yes,
Pardon, my lord.
it is a common fresh admission. It will be the top of the list and we'll decide at this stage only. All right.
Well, I congratulate your lordship, my lord.
Okay.
Item number 8.
May I please, Your Lordship? May I please, Your Lordship? Like here, the appellant has challenged the order dated 25/7/2023 passed by the learned single judge, when the learned single judge relegated the matter to the respondent, that is the block education officer, without adjudicating the matter on merit, my lord. Lordship, kindly have a glance at the order passed by the learned single judge under Annex 8, my lord.
Yes, I have seen this order. Okay.
Well, in original writ petition, I am challenging the order of reversion, my lord. Lordship may come to page 33, my lord.
We are admitting the matter.
I have one submission to make, Your Lordship.
Yes.
Your Lordship may kindly have page 28, Annexure 6. The writ petition has not been annexed, but from the impugned order, it seems that this was the impugned letter under challenge. This is not addressed to the petitioner. This is not even addressed to the rank that the petitioner has achieved. This is a general circular that if any promotion has been granted in violation of the rules, he may be reverted. And the learned single judge has said that since no final order has been passed, if any coercive action will be taken against the petitioner, then he may be granted the opportunity of being heard.
My lord, this is the final order. Lordship, kindly have a glance.
This cannot be the final order.
My lord, Lordship, kindly have a glance. My lord, basic upon this order, they are reverting me, my lord. My lord,
They have reverted you or not?
no, they are taking steps to revert me, my lord. That's why I have challenged this order before the learned single judge, my lord. Lordship, kindly have a glance at
Just, we'll be taking up the matter on 14th of August.
Your Lordship.
You please bring the records.
Your Lordship.
Right?
my lord.
Well, counter.
I have a small claim. Till then, my lord, this order may not be given effect to my lord. Because my lord, they are taking steps to revert me, my lord.
All right. We can also set aside that order. We are fixing on 14th of August.
My lord, only small plate till then, my lord.
No, you are unnecessarily insisting something that will not happen in this court. Yes.
But the only issue is
that was listed on 14th August. We'll request Mr. A. Behra, learned Additional Standing Counsel, appearing for the respondents, to produce all government records relating to the annexure 6 to the writ petition. It is a 6 to the writ petition or the memorandum of appeal?
To the appeal, Your Lordship.
Memorandum of appeal. All right.
Well, this order is passed, my lord, contrary to the rules. Well, rule
That you will get the opportunity
Yes,
on 14.
but till then, my lord, I pray, my lord. I have a small prayer, my lord.
Case wine.
Case why, my lord.
Case one, Lord Council is appealing for the appellant. Nothing would happen if nothing has happened so
My
long.
lord, but they are taking steps to revert. Now they are taking
So,
steps.
brother, this advise them not to take any step. We
Your
are not
Lordship.
reflecting. Yes.
Item 9,
Obliged, my lord.
item number 9.
I please, Your Lord. This writ appeal is directed against the judgment of the Honorable Single Judge. You also kindly come to page 83, the judgment of the Honorable Single Judge. What are the prayer made in the writ application? Just I will show your worship, then I will take your worship what is the finding.
Okay.
Page 83, annexure 8. Let's get it. By filing the present writ application, the petitioner who are
What
16,
you are referring to?
I am referring to the first paragraph, first paragraph of the
Yes.
writ application. By filing the present writ application, the petitioner who are 16 number have questioned the selection process adopted by Odisha Public Service Commission by shortlisting the candidate who had submitted their candidature pursuant to advertisement number so and so under Annexure 1 issued by the OPSC on the principal ground that the procedure adopted by OPSC for second stage of selection, that is violated as illegal, arbitrary and devoid rules. Next slide. Moreover, they have also prayed for quashing of the merit list, shortlist list published in notice dated so and so by the OPSC for documents verification and under Annexure 5 by declaring the procedure followed by the OPSC, shortlisting the candidate for recruitment to the post of ASO is illegal. Further, they have prayed for direction to OPSC to prepare a fresh select list of the candidates by taking into consideration total aggregate mark in all subjects. This was the prayer made in the writ application. You also kindly come to page 97. We are not parties to the writ application. That is why I am bringing to your lordship's notice first, then I'll take to your lordship to the merit. Page 97.
You are affected by this?
Yes, I am directly affected. I'm coming to that. Squarely covered by your lordship's judgment. Page 97. Para 14. Let's get it. Page 97. Running page 97.
All right.
Para 14. The next question that have raised in the counter affidavit is by the state as well as by OPSC. Affidavit is non-joinder of necessary party. In the said context, it is stated in the counter affidavit that the petitioner essentially seeks for a direction to withdraw the select list already prepared and published by the OPSC. However, none of the candidates from the select list dated 7/11/2022 have been arrayed as party, even though their selection is under challenge. As such, the writ petition deserves to be dismissed. This is the counter filed by the state and OPSC. Let's come to the next page as page 98. The points were formulated by the Honorable Single Judge, A, B, C. Nothing so far as this aspect is concerned. And the judgment also totally silence about this aspect. This specifically that the person, those who are like affected, they are not made parties. Now you also kindly come to just 1 minute. You also I filed a review application before the Honorable Single Judge. Because we are directly affected, so we filed a review application. You also come to Annexure 9 at page 171.
That is the order of the review?
Review, yes. That is also 58 pages of the review order. At the stage of admission, fresh admission, it has been disposed of. Page 171.
171.
Yes, sir. That is the judgment of the review starts.
Anyway, this is the case-wise brief statement of fact, first recorded.
Sir.
Then you come to the conclusion, better.
So for the conclusion, the judgment.
Review order.
I'm showing why there is some point. That is why 171 is the start of the review judgment. Let's say come to page 186. Why I'm saying so? Because that is the finding. 186. Let's get it.
186.
186. Internal page 16 of the review judgment. One paragraph also, that is,
yes.
Before awaiting the answer to the question, this court, para 16, this court would like to clarify at the outset that in course of argument, Mr. RATHO and senior counsel appearing for the petitioner laid much emphasis on the ground that The judgment dated 19/5/2023 is unsustainable on the ground that the petitioner were necessary party to the earlier litigation were not arrayed as opposite party and they were not given opportunity of hearing the violation of maturity. Let's come to page 187. Next page. Fourth line. Petitioner assailed the judgment. You also get it. 187. Petitioner assailed the judgment dated 19/5/2023 on the ground that the said judgment is required to be reviewed on the ground that petitioner were not added as opposite party and as such they are not heard before delivering the judgment dated 19/5/2023. On the analysis of the ground other than the non-joined or necessary party as taken in the review, as well as the petition, this court is of the considered view that such grounds are based on merits of the matter which can only be challenged by filing an intra-court appeal as provided in law. Then also kindly come to page 216, the operative portion of the two paragraph, to page 216.
Okay.
In the aforesaid background, this court now records its finding to the issue formulated in the preceding paragraph. The first ground that was formulated by this court was to whether the ground taken in the review petition are good grounds, and accordingly a review petition is entertainable on such ground, question mark. In reply to the said grounds, this court is of the considered view that the grounds with regard to non-joined or necessary party, which was emphatically argued by one senior counsel, is definitely a good ground, so far as maintainability of the review petition is concerned. With regard to the other ground taken in the review petition, this court would like to record that such grounds are based on the merit of the issue, which has already been decided by this court in the writ application. Therefore, in the event the petitioner agreed by the finding of the court that they have been ill-advised to challenge the same by filing an inter-court appeal. Thus, the first issue is answered accordingly. Then the review petition has been discussed at page. Now you also come to the merit.
You come to the para 42.
Para 42, yes, sir. Para 42. Yes, 42, yes. That is at phase. Accordingly, both the review as well as the writ petition. Sir, I understand what you are saying.
So we are admitting.
Sir, now the content is said that the problem is this.
My lord, I am for instruction to appear on behalf of private respondents. My lord, so far as party is concerned, my lord, that is totally, argument to lordship will say, they are not at all necessary parties, and that part has already been.
Then my lord, for a moment, there has to be a judgment. Yes, judgment of this court.
Sir, kindly look at this.
Sir,
please have it.
No, Mr.
Please maintain calm.
Sure.
I'm asking a question to Mr. Mishra.
Sure. Then, sir.
Mr. Mishra, whether by the order of the land single judge, the initial selection of these, now the writ appeals, were set aside or not?
No, well, the selection is not, lordship, kindly see, for a minute or the provisional selection. They are not considered the provisional selection list, and that too, based on the rule, and who are the selected list, only the allotted, roll numbers. Only roll numbers are there. Look at that.
Whatever the roll numbers there, my question is whether their selection is affected or not. Answer must be yes or no.
No, madam, they are not selected at all. They are not selected at all. Only they are written in the they are only selected in the selected in the written test. Other tests were not completed. At that stage we had come because at that stage they immediately so PhD came that we have to fix a minimum qualified marks.
According to you, they do not have any right of audience.
No, right of audience.
That is why that's
right of audience are not. Judgment cannot be.
All right, you are really.
But whatever Mr. Rautra argued, that was our argument before the.
All right, we understand. All right.
But the quantum stone is hanging on our head. So unless they protect us, then we will put it up.
We have the better experience. But you store the judgment up to the next date. You have to see the matter. 21st of September for the final year. Right?
Let that not be final selection.
Yes, sir. So that should not be any process at all.
Yes, sir. Yes, sir.
Right.
That.
No, the intra-court appeal.
Not procedure.
All right.
No, serial number 19 is the intra-court appeal. Madam.
Yes,
Yes.
Another is
Yes.
9 and 19 same.
9 and 19.
19 against the judgment they have filed here after review and read.
All right, all right. But 9 and 19 need to take place. So
Since everybody is here, no notice need be taken.
Please interpret. Mr. P. Rautre, who is assisting you?
Mr. Rautre?
Mr. Rautre.
Yes, Radha.
Yes, Rautre. My views of this intercourt appeal.
Review judgment as well as High Court judgment.
The judgment dated 31/7/2023 as cost RVW PET number 257/2023. By which judgment, the judgment dated 19/5/2023, passed in WPC number 32174, annex 8 to this memorandum of appeal, has been affirmed. Stop. We have prima facie consider the materials and find this is an appeal which has to be admitted to be heard on merit. Admit, issue notice. Since the parties are represented by the council, no formal notice is called for. Just all, you have to issue notice some other opposite parties.
I don't think. All are,
Since you are appearing for all the opposite
All
parties.
private property.
All right, all right, yes.
Others are government, state government and PSC.
No, that is right. All right. Our concern is only the private individuals.
We are appealing for all private.
All right.
That is 1 to 16.
Since, who is assisting you?
This is A. Senapati.
Since Mr.
Okay, Mishra.
M.K. Mishra and Senior Counsel listed by S. Senapati, Learned Counsel, appears for the respondents number 1 to 14. 16. And Mr. M.K. Kamtial and Mr. Behra.
Bishop, your lordship may record my name.
Mr. A. Behra and Additional Standing Counsel appears in Rape's notice for
UP 17.
respondent number 17. And Mr.
P.K. Mahanti.
P.K. Mahanti is stood by
Ketty Mudali. Miss Ketty Mudali.
Ms. K.T. Mudali, Learned Counsel, for the respondent number 18 and 19. No formal notice is called for. Everybody is getting the memorandum of appeal?
No, they will have to sub.
I undertake to sub.
Mr. Rautre.
I am sorry.
Learned Counsel shall supply a copy of the memorandum of appeal.
Already started.
Has served copy of the memorandum of appeal with all enclosures. Stop. Considering the nature of the case, considering the controversy raised in this writ appeal, we are of the view this matters required expeditious hearing. Let the matter be listed on 21st of September 2023 for disposal on merit. Stop.
I supported. Very good.
You have not filed this certified copy.
I undertake by tomorrow. I have already got it.
This is IN number 4934. This is an application for dispensing the filing of the certified copy of the judgment dated 19/2023, passed in WPC number such and such, and the judgment dated such and such. Just show the cost.
I think that I is the other eye.
Stop. But downloaded copy of those judgment in order. Judgment
Yes, downloaded copy I'll give you.
close to the memorandum. But today, Mr. Rautre and Senior Counsel has understood that by tomorrow the certificate copies also will be filed.
Review judgment I have obtained the other judgment.
All right. In view of the said undertaking, we dispense with the filing of the certificate copy of the judgment dated 19/5/2023, Passing such and such and judgment dated 31/7/2020. Accordingly, this application stands disposed of. The next item, this is an application for staying the operation of both the judgment. This judgment having blessed the grounds taken in the appeal, as well as the observation made in both the judgments of the view, both the judgments shall be suspending disposal of the connected intercourt appeal being WA number 122 of 2023. That and also the other order, 19 was the 19. Such and such. In 19, will also pass a short order in view of the order passed in this appeal is also admitted. Notice served, admitted, and notice served to the parties. You also 19. So that will be listed on for hearing on maybe read PWL circumstances.
In 19, interim orders. In 19,
by Mr. Dave.
because there are no further process, we will not proceed further. It's not only passed up. Yes, but I am. Oh, sorry, but I am not.
Next.
Sir, so far the judgment of the Honorable Single Judge, so far the writ petition is concerned, I was told that we cannot get the certified copy, but we have got the certified copy of the review because we are the petitioner. But that
you cannot get the certified
because they are not, unless they are parties, the office said that if you are not a party, you can't get the certified copy. That is what I was told just now.
That's rule.
Dispose of this party of the only pending case, that is the rule. Pending case, that is the rule.
Otherwise, make the registered
yes, no,
okay.
In 19, my name may be reflected for opposite, but number 7.
Oh, yes, this in 19, just change the bearers.
Mr. Dale.
Your Lordship has suspended the judgment. So, this selection will not proceed.
No, nothing. Judgment is effect is taken.
I have filed
In
item number 19.
For whom? Petitioner?
Yes.
Then you are doing on Mr.
Along with Mr. Dari.
On the case, similar order, it was the similar orders. Yes, next case.
Item number 10.
May I please spell out?
Where? Mr. Rautre, Mr. M.K. Mishra, there is a problem in item number 19. There is a delay, my lord. I think we can condone the delay.
25 days.
25 days. Condone the delay. That is why. As agreed by the council for the parties, give the name. We condone the delay that is occurred in filing the intercourt appeal. The judgment is saying, all right. Yes.
May I please, my lord? Item 10. Item 10, my lord, I'm sorry to say that there is a small mistake in the index and the presentation. I may be permitted to correct that first, otherwise it will be difficult for my lord, for me to address your lordship.
All right, what kind of defect you show us?
My lord, my lord, Annexure 1 is the impugned judgment of the Honorable Single Judge. But by mistake, it has been stated of the writ petition with the annexures. By mistake, it has been stated the copy of the writ petition with annexure has been annexed as Annexure 1. It should be the impugned order of the learned single judge. Yes, my lord. And that is the only mistake. The presentation has to be carried out, my lord.
Right. Let the matter be listed on 14th August 2020.
Certified copy.
Mr. Your good name, sir?
My good name is Rajit Roy, my lord.
Mr. Rajit Roy, and counsel appearing for the appellant is submitted that in the indexed mistake has.
Replace the index.
That is what I'm going to do this.
But my lord, may I pray for Friday, my lord? I'll correct it tomorrow itself.
It's in the IA, there is no affidavit.
That has been corrected, my lord. That has been, that defect has been removed.
That in the indexed under Annexure 1, it has been stated the copy of the writ petition and annexure. It should be this, but certified copy is the Annexure 2.
Yes, my lord. That should be Annexure 1, my lord.
And annexure 2?
Annexure 2 is the writ petition with annexures, my lord.
There is some mistakes in the index. And the appellant needs to correct the said index. Otherwise, that may create confusion. We permit the appellant to change the index and file a fresh index before the registry. Let the matter be listed on not Friday. Friday is single bench mostly. On 14th, come on 14th. All right.
Mr. Rai, office note shows that it has not been removed. If you have removed, well and good. Otherwise, you do it.
On 7th it has to be removed, otherwise I will take steps on that.
Item number 12. Item 12.
This.
Item 12 and 13 both are similar matter.
Mr. Who is appearing? Nobody is appearing there.
I'm sorry, Malad.
Oh, yes.
Malad's item 12
and 13.
12 and 13, Malad's. Malad's petitioner is challenging the inaction of the opposite parties in not implementing its own order of closure of brick kiln, which has been specifically directed.
I'll take instruction 2 weeks time.
Not 2 weeks time. It will come on 21st of August. At the request of Mr. D.K. Mohanty, London Council, appearing for the opposite parties, let the matter be listed on 21st August 2023. Which is the order that they are not implementing?
An annexure 1, Malad, the closure order which was issued.
Mr. Mohanty, London Council shall take instruction whether the order dated 24/6/2016, annexure 1 to this writ petition has been executed or not.
Yes.
Stop. Such instruction should be in writing. And
I will file a short affidavit.
all right, stop. At this stage, Mr. D.K. Mohanty, additional government advocate, submits that the opposite parties who are under obligations to execute the said order shall file short affidavit.
I'm grateful.
P.P. Behra, London Council, appears for the petition. Petitions in both the cases, single order pass, combined list 12 and 13. Yes.
I'm obliged. Item number 14.
Please correct your synopsis.
Yes. Yes.
Challenging the direction of disclosure.
No. Disclosure. Yes, I correct.
That's closure.
Closure.
All right.
Item number 14.
14, my lord, notice was issued to the opposite party to file counter, my lord. The matter relates to promotion, my lord. Promotion was denied to the present petitioner and his junior was promoted. Against that order, the petitioner filed way before the state administrative tribunal.
You also went to the Supreme Court.
Yes, ma'am.
And now you're filing the review petition.
As per the order of the Honorable Supreme Court.
So what is the Supreme Court order? Let us.
My lord, page 94, my lord.
All right. In a review petition, what is the necessity of a counter affidavit? In a review petition, what is the necessity of a counter affidavit?
Notice was issued.
I understand notice not for counter affidavit, notice of hearing that other party will be heard.
There is a private opposite party for that notice has been issued.
Notice was issued, yes. Now they have appeared, I think.
No, no one has appeared as it appears. No one has appeared, my lord.
All right. It appears from the registry's note dated 13/4. That is the respondent number, the opposite party, this 3, I think. That despite due service of notice on the opposite party number 3, none has appeared till now. Stop. Since the service is complete, this matter will be taken up for hearing on 18th of September 2023.
Just one moment. OP3 is the private party,
Yes, yes.
but that tracking report has gone to Baripada.
Yes, my lord. In the meanwhile, he has retired from service and now staying at Baripada.
But the address in the review petition is Sambalpur.
Yes, my lord. At that time, he was, what the notice was issued to his Baripada address, permanent address.
When?
You filed the corrected address later on?
Yes, ma'am.
Okay.
No, they have filed from the very beginning the different address.
It has been served, it shows the postal department.
Oh, other details are there, only the place is there.
Yes.
Item 15.
In my lord, we have filed the requisites, but it has been filed
late. All right, Mr. P.K. Mudali, London Council, appearing for the appellants, has submitted that the requisites for the appellant, the requisites are filed belatedly, and that is the reason why the registry has not issued the notice on the respondent. Step. We direct the registry to accept those requisites and issue notice on the respondents. Returnable on 29th of September 2023. 29th of September.
Well, here, yesterday, my lords have adjourned the batch of matter to 5th of September.
This is a related matter.
Yes, similar.
For the 5th September. Okay.
Item 16 also.
16 also same.
Similar order. Yes. Deleted.
Yes.
No, it. All right. Same.
Item 17.
Yes, I am for the appellant, my lord. There is
delay.
30 days delay.
Defect.
And there is also defects.
Defects, my lord. And you remove the defects.
So we are fixing the case on 31st of August to remove the defects.
Right.
At the request of Mr. G.S. Sethi and Council, appearing to the appellant, let the matter be listed on 31st of August 2023. In the meanwhile, the defect is identified shall be removed by the appellant without fail.
File a certified copy. Not filed.
Item 18.
Item 18, may I pay you submit?
I am appealing for response.
May I pay you submit this tomorrow or day after tomorrow? Because that original read petition is not with me.
No, we have also filed a caveat petition, which is at flag D.
You will be supplied everything right now.
In course of that, I will supply the copy. Tomorrow or day after my lord's convenience.
All right. So this is on count 14th. It is the matter on 14th August 2023 for the request of Mr. N. Contiel and Council for the appellants and Mr. S.P. Jaina.
Yes, my lord.
You are appealing for the sole respondent?
Respondent, my lord.
All respondent?
All respondent, my lord.
And Mr. S.P. Jaina and Council appears for the respondent.
Respondents.
Respondents. All right. The copy are not served on you?
Copy is not yet.
In course of the day, sir.
Mr. Contiel has assured this court in the course of the day, memorandum of appeal with all enclosure will be served on Mr. Jaina. I is there?
Yes.
Limitation.
Along with the I.
Copies of the IA also is served. 3 IAs are there.
I'll serve all.
Serving the caveat petition. 63 says Mr. S.C. Jaina, Council has appeared for the respondent in the appeal. This caveat is discharged. Appealed for the respondent and accepted.
Item number 22. Item 22.
What happens to 21? Are they ordered first?
All adjourned, so one way these people may not be. 22.
Yes.
I'm sorry, my lord. Lord, this writ appeal is against the Honorable Single Judge's order, where a common order was passed in respect of 3 writ applications. But unfortunately, the 3 writ applications involve slightly different facts, but it has been painted in a single way, as if I have not done anything so far as the land is concerned. And no development was taken up, no manufacturing process was carried out. So that was in respect of only one of the properties, but the other 2, in their counter affidavit, they have admitted that yes, there has been a construction and the factory was operating. So on that basis, the impugned order was passed. I'll just take your lordships to the order.
Annexure 13.
Yes, please. If your lordships would come to page 38.
Yes.
The 3rd paragraph, Mr. Bhokta and Mr. Samantha. It starts the 3rd paragraph.
Yes.
Mr. Bhokta and Mr. Samantha, learned counsel for the petitioner, submit that the petitioner has constructed a building and started infrastructure thereon. However, no document has been filed by the petitioner in proof of the petitioner purchasing any machinery or establishing any plant on all the 3 plots allotted in his favor. In the meantime, as many as 32 years has elapsed and about 11 acres of land which is in possession of the petitioner is lying unutilized. If your lordship will just see the reply that was filed by them in their counter affidavit to the writ petition.
Why you filed the writ petitions?
No, because the land was sought to be resumed by IDCO.
Okay.
Stating that for the purpose for which it was allotted,
it was not been
utilized and not been carried out. So I have given also along with the.
So there are 3 plots.
There are 3 plots. So in respect of
in one writ petition, you have done something. At least you have
2 writ petitions.
2 writ petitions. But there was no. You have not started operation.
No, operations had started. I had given the work orders. I have given the invoices that has been raised. Everything.
Have you served notice on them?
I think on the last occasion, Mr. Mukherjee was appearing, and on the verbal understanding before the court, we had paid the dues also. It was. Whatever the outstanding dues up to 2019 when the matter was taken up, that was also paid.
But the records, there is no reflection of such transactions anyway.
And that is not there, but it has been paid. Your lordships can take down my version also, reflect it in the order that up to date, up to 2019, it has, 2018, it was paid.
No, we're not unnecessarily records thing. This is not the issue before us.
Yes.
The land is lying like that, unutilized.
No. We are carrying on activity in the respect of 2 lands. One is, of course,
it has got any standing counsel in this High Court?
Yes. Yes, already appeared something else.
I think Mr. Mukherjee was. Mr. P.K. Mohanty, I think he is now appearing on behalf of what my learned senior Mr. Mohanty says.
That means Mr. Mukherjee is no longer appearing.
Maybe, my lord, I'm not. So I'll serve a copy on him and also.
Already heard Mr. D.P. Nandavan, Senior Counsel. Who is assisting you?
Mr. Sachin Sahu.
Mr. S. Sahu. It appears from the records. The appeals are awaiting admission. Stop. Issue pre-admission notice. Where?
Date is.
Notice was earlier issued. Your lordships may say we will serve a copy. Or fresh issue of notice or whatever subject.
18-4. Order number 3.
Already. So, It appears that on 18 to 2018, notice was issued. And Mr. G. Mukherjee and his senior counsel had appeared for the respondents. But today there is no representation. In such circumstances, we ask the appellant to serve the fresh notice on the respondent by Dosti. Yes, let the matter be listed again on 31st August 2023.
May I pray if you also can fix up in any date on the first week, because my learned friend will not be available on 4th or 5th. See, 4th.
It's 5th. The affidavit of service shall be filed by 31st of August 2023.
Item 23 and 24.
I think Mr. Mukherjee's associate has just come, so your lordships can. So, no,
are you appearing still in this matter?
Yes, your lordship.
Okay,
sure.
Yes, your lordship.
Then wait.
Then that is where your lordships fix up a date so that
file the Bagalatnama in this case.
I am appearing on behalf of Mr. Gautam Mukherjee.
Mr. I am concerned about the advocate on record.
Advocate on record.
My name is.
No, unless you file the Bagalatnama. You asked to, you filed the Bagalatnama.
Lordship, I'll do.
Taking up the matter on 5th of September. 5th. It has been, your name?
Mark Wright.
Mr. Mark Wright, learned counsel. Appearing to the respondent has prayed for some accommodation for filing the Bagalatnama. The Bagalatnama shall be filed by the next date, filed in such and such.
Obliged.
Item 23 and 24.
All three, all 22, 23, 24.
24.
Item
the
common order. The same.
No, I thought actually against one company this.
No, my lord. Against separate companies. Three separate companies. That was the lord issue.
So you are also appearing that case also?
Yes, my lord.
In all three, I'll file Vakalatnama.
All right.
The same counsel.
There is other counsels also there already. So just
I'll clarify.
No, not clarify. You take their signatures on the Bagalatnama.
Lordship, I'll do that. Obliged.
Yes.
Item note 25.
Mr. Mukherjee, what is the matter?
My lord, I have challenged the judgment of the honorable single judge. Honorable single judge.
You are appearing for someone.
My lord, your lordship, kindly have a glance to the previous order passed by the
My lord, on merit, I am taking to lordships.
No, it is before the merit, the writ appeal has been admitted only a limited ground, whether the 75% of the area will be paid by the management of the school or the government. And regarding the reinstatement, there is a specific direction by the honorable single judge, and that after this honorable court division bench also, on the last occasion directed that let the respondent number 5 be reinstated in service. He is a class 4. He is unable to come from Kalahandri to file an affidavit with. His economic condition is so wretched. Both the managing committee and the state authorities are playing with the respondent number 5.
This is a granted school. It's
Granted school, aided school, my lord. Aided school, my lord.
According to if the court directs to pay the 75% of the make wages, it is your obligation because the part of the pay and allowances. What is the issue in that?
Lordship, may I call this matter on Monday? I will take instruction and
take instruction. We list on incidents.
And on 8/2/2023 is an order for reinstatement.
The management.
I have postponed, I have made ready an affidavit regarding reinstatement, my lord.
You file Monday will take up
Monday. I am filing on the registration.
Council appeal for the the opposite parties, respondent number 1, 2, 3.
May I pray a copy of the writ appeal be served on me?
Yes.
A copy of the writ appeal.
Doesn't served.
Nahi mo file
Actually, extra copy I served on second 11 mile.
I don't dispute that file
is requested by this court to serve a copy of the memorandum of appeal with all enclosures to Mr. Kuntia in the course of the day. Okay.
By tomorrow, my lord.
Mr. Samuel, by tomorrow. Okay, by tomorrow.
In course of day, my lord,
in the course of the day.
What is it will be difficult on my part.
All right. By tomorrow. Mr. Samuel, counsel has appeared for the opposite respondent number 5 stuff. So Monday will take up the matter.
Yes, ma'am.
It is your obligation.
Yes, ma'am. I'll take.
And reinstatement, my lord, managing committee is not there. Headmaster is not competent to reinstate. I wrote letters to the district education officer.
Administrator also.
Pardon, ma'am?
There is no administrator.
District education officer, the management has been vested with him.
You already ask him to.
He has not given me any instruction to reinstate him. My lord. I wrote twice.
By Monday, you take the instruction.
My lord, Mr. Kuntia,
I'll take instruction.
You take instruction. Yes.
Item number 27.
Pursuant to your lordship's order. My lord, pursuant to your lordship's order, the SP Puri has conducted inquiry and the report has been submitted to you.
All right, let us see the report. So according to you, it is not the SC dominated area.
That is what the report reveals. The last sentence of para 6, your lordship, there is no complaint of barbar caste people in the village. Although IIC Brahmagiri took all possible and sincere efforts to contact with Sri Sesadev Subudhi, petitioner, but none of the locality could able to say present whereabout of him. On being contacted with Ashok Sethi, reported that he want to return to his village, Nuagan, with so and so, with an amicable settlement with the village committee. There is a dispute among two groups of people, and
same community.
Same community. Lord, now the petitioner is not traceable according to the report of the IIC. Now the petitioner is represented by his advocate. Let the petitioner appear before the IIC Brahmagiri so that he can give any sorts of assistance. What your lordship will direct.
Whom will be direct? Advocate is also not there.
Sorry.
Mr. Pradhan is not here today.
Yes, he is also not here today.
But the matter will be listed on 14th August 2023. No, just wait for 1 day. And Mr. D.K. Mohanty, and additional government advocate is requested to inform Mr. Pradhan.
I shall inform.
Inform him that
yes,
so that either
yes,
he's
yes.
Pradhan, counsel, who appears for the petitioner but not present in the proceeding today. All right. The report filed by the
SP Puri.
Superintendent of Police Puri is taken on record.
Obliged.
This is now situation. That is why, because this is the petition is not traceable. That is open. Yes.
Item 28.
Item 28, may people lordship. Kindly have a look at the order dated 2/3/2023, para 1, my lord.
Appeal judgment?
No, my lord. Order dated 2/3/2023, first para, my lord.
2/3.
My lord.
Yes. They have not paid?
No, my lord.
My lord, will kindly see the next order. My lord, learned friend is not sincere in the merit of the case. He is insisting for the cost. Next date order may kindly be. 5/5/2023.
These have been waived.
That has been waived.
But counter copy has not been served to you.
Counter copy you did not receive. That is the specific. I am just now serving the counter copy. Just now. You did not receive. That is my instruction.
That should not happen.
No, that hasn't happened.
That has happened because of that cost matter.
Not all right. Forget about it. We are requesting that instruct the clerk properly.
No.
If there is any difficulty, they should come to you as a council and then only they can refuse. If
There is no such information that I have not received.
Partial complaints, that is why they did not receive. You were not giving the cost, so maybe that is why.
No. Cost is subject to non-filing of counter affidavit. And that has been waived by the Honorable
That's
Court.
subsequent.
Subsequent. Right now.
That should be mentioned by you. Na? That has been
All
waived.
right. Don't cross.
You are there.
All right. Mr. Mahanti just supplied.
Right now. I am giving it right now.
So you will be need some more time will be required. Yes.
We'll file the reason. We'll file a common agenda for all the opposite.
It will come on 11th of September.
11th September.
Well, the matter will be listed on 11th of September 2023. Meanwhile, if the petitioner is interested to file any rejoinder affidavit, that shall be filed as no further accommodation will be made. Mr. Mahanti, D.K. Mahanti, the National Government Advocate, has supplied a copy of the counter affidavit that has been filed by the opposite parties to Mr. Satapathy.
Item 29.
Much obliged.
You also state epic. Mr. Kumpi, are you appearing in this matter?
Yes, ma'am.
My lord, state has filed the request.
First, there is an IA.
Delay is there.
There is no delay. In fact, there is no delay.
According to you, there is no delay.
Before he submits, may I submit one thing, my lord? As a matter of fact, I don't have
delay.
I don't have power in this case. My learned friend was appearing today on appearance memo. Your lordship may allow me to appear. Now you submit.
Delay nahi.
That's all right.
COVID
That's all right.
Lordship, the order is on 23/2/2021.
23/2/2021.
So during COVID period, there is no delay. This writ appeal has been filed on 24/2021.
Judgment is
23rd February 2021.
Further stamp report है कि ना आगे तो कर लेनी stamp report.
Due to non-filed, but that copy.
No.
Main committee देखिए.
They have also not report delay.
Yes, ma'am. That there is a report that not.
That is all right. Is there no delay? No, they have not mentioned, and they said because of the Supreme Court order, the stamp reporter has made a note that according to the decision of the apex court in decision of the apex court,
Great.
by order dated 4/3/2021, passed in Suomotu WPC 08 of 2020. There is no delay. In view of this said observation, This interlocutory appeal 930 has become inessential and according the same is disposed of. Stop. These other, that have you filed the certified copy by this time?
That my file does not show that only it shows on 10/11/2021 they have applied for the certified copy. I will verify that.
All right, let the matter be listed on 14th August 2023. No, this is not done. Yes. Stop.
Yes.
The request is yes. Until and possibly to the prediction and copy. It's already come on 14th, let them whether certified copy. On instruction of what is your name, sir?
Sushant Kumar Mishra.
Sushant, you are already there.
Yes, Mr.
Okay.
Bimbi Sardas.
Oh, Bimbi Sardas. I told that will be reflected on instruction. That is what I told.
Yes, ma'am. Bimbi Sardas. This matter can be disposed of.
Let me see what is whether they have got the certified copy. Otherwise, you have to dispense. You will dispense if the certified copy is placed. That is why.
Why I was submitting, my lord? Why I was submitting that? On the plea of pendency of the criminal proceeding, additional proceeding which was initiated in the year 1977 is pending till date. In the meantime, 2001 I retired. I am not getting my pension, regular pension. In the meantime, I have been acquitted in the criminal case.
That he has given me a copy of the judgment on the basis
criminal case I have acquitted.
All right, just wait.
On the
basis
instruction. On this basis of judgment, your lordship can dispose of the writ appeal. But we are affected with two parts. One with the interest part and second with the cost of 10,000. If that will be waived and other postal dues be released, that I have no objection to it.
Cost may be waived, but interest
not entitled. The judgment is just now. What is the date of the judgment?
Yes, madam.
Interest may be from the date of judgment, not from 77.
On the date of judgment in the criminal case is 2. But he said that 9/2/2023.
Yes. I don't.
How can you get the interest?
I'm not.
Before that, you cannot get any.
Yes, that's my case.
Because these are a very grey area.
I understand. I understand.
Yes. It is a discretion of the employer. Employer has to go to the content.
Your lordship dispose of.
All right. So dispose of.
That cost part and interest part.
Interest, no interest.
And also they have a cost of 10,000. Your lordship can.
Already we are waiving, but the entire payment has to be made within 7 days.
Yes. 7 days, some more time. Because
15 days.
1 month, your lordship.
No. This is all now the.
He's getting provisional pension.
Nothing of that.
80 years of age.
Yes, madam. That
1 month.
1.
All right.
Everything is pending.
All right. This is your W. 531 of 2021. No, this appeal number.
My
judgment.
369.
369 of 2021.
29.
Let's go over the earlier order. Let's first take the dictation in.
IA 929. Oh no.
That is already done. I 929. Mr. M.K. Kuntial and counsel has submitted that the appeal was filed without obtaining the certified copy by a downloaded copy of the judgment. The downloaded copy of the order dated 23/2/2021, passed in WPC number 344 of 2021. Mr. Vindisha Das and counsel appearing for the opposite party has stated that if the filing of the certified copy is dispensed with, they will have no objection. And accordingly, the filing of the certified copy is dispensed with. And the results, this application stands allowed and disposed of in the main appeal. By this intercourt appeal, The order dated 23/2/2021 passed by the single judge in WPC number 3344 of 2021 has been challenged by the said judgment. By single judge is directed that in view of the inordinate delay in disposal of the retail dues, the petitioner will be entitled to interest on the retail dues at 6% all through stuff. Interest on the retail dues be calculated and remitted to the petitioner by completing the entire exercise within a period of 1 month from the date of calculation of the retail due, failure of which petitioner will be entitled to the interest of at 8% all through stuff. That apart, a single judge has imposed a cost of
10,000
to be paid to the writ petitioner, the respondent in the writ appeal. Writ appeal. Stop. Mr. Das Learned Counsel has submitted that the petitioner acquitted from the charge by the order dated 9th February 2023. Acquitted from the charges is framed under section 409/468/101 of the IPC by the order dated 9/2/2023. Delivered in trial case number 436 of 2021, corresponding to GR case number 268 of the first federal capture rate of 1972. So, as such, from since 9 to 2023, the respondent did not suffer any stigma, providing any ground to the appellant to withhold the payment. The said order of acquittal is taken on record. So, it has been agreed by the council that the respondent will not claim interest as directed by the single judge, nor would he claim the cost from the state. So, in view of the above statement made by the Mr. Das Learned Counsel, appealing for the respondent, we dispose of the appeal, directing the appellants to pay all the repair benefits of the respondent within the writ petition within 30 days from today. If the payment is not made within 30 days from today, the appellant shall pay interest at the rate of 7% with effect from 9 to 2023. Now pay an additional amount of 50,000 to the writ petitioner. If you pay within 30 days, nothing. Already. The urgent certificate copy of the on application.
May I submit one thing? Provisional pension may be made regular.
Yes, provisional.
I have stated 30 days.
He is getting provisional pension.
Yes, but what we release the.
He is getting.
It is made clear that within the said stipulated period, petitioner's regular pension shall also be released. All right.
Item number 30.
Only one line, he had to cooperate for preparation of his pension paper, otherwise you cannot.
Provision shall extend all corporations to preparation of the, I think that he has done it already, just check.
No, because of his latches, he is not moving.
All right. Provision shall file necessary papers to process the regular pension. If any delay occurs for the latches of the petitioner, that should be added to the period that we have stipulated.
Yes, ma'am.
All right.
Yeah, time.
No. Someone should, in advance you send those.
Yes. All the papers which is required.
Right.
Item note 30.
30, my lord, here I am for the respondent opposite party.
Yes.
I pray with time to file the replies.
What reply?
Because earlier occasion, there is specific order. Can I have a glance to the order dated 15/2/2023? 15/2, my lord. Here, my lord, this is the appeal at the instance of the government.
Right.
The delay was condoned.
Yes.
Certified copy filing dispense with. And my lord, the order number 6. A reply is to be filed.
What reply?
No, that is the order, my lord.
No, then you forget about it. It is a writ appeal.
Yes, ma'am.
All right. Are you ready for hearing today?
Yes, ma'am.
We'll take up the matter.
Yes.
Yes.
Well, page 40, the input order at annex 2 mile.
Yes.
May I read this? Background involved in the case is that on 4/11/2006, an advertisement was brought by the Chief District Medical Officer Cuttack inviting application for one post of laboratory technician pathology. Consequent upon test among the participants, select list was prepared in which the petitioner, since stood at second position, was placed in the voting list, giving scope to the first candidate to join the post. Further fact disclosed that first selected candidate did not join, as a consequence of which the petitioner was engaged as a laboratory technician on contractual basis by Annex 3 on 19/5/2007. It is while the petitioner continued as such in the year 2012, he was issued with the input order of termination, resulting filing of writ petition. Petitioner is continuing in service by virtue of interim order of this court. The Land Council for the petitioner taking court of the condition in the advertisement at Annex 4, the qualification criteria, more particularly submitted that in consideration process, it has been clearly observed that in a recruitment process, no qualified candidate could be available having laboratory technician post, examination passed from 3 medical colleges of the state. Further, taking this court to the government communication dated 5/10/2006 by the Annexers 8, Siddharth Land Council also contend that finding difficulty in getting the particular type of candidates, government has already moved for condonation of the condition for the candidates having certificate from particular institution. Further, taking this court to the nature of interim order, Siddharth Land Council also claimed that only there is scope for condonation of the required qualification certificate. For the petitioner's engagement as a contractual laboratory, though a recruitment and further petition continues for over 13 years, holding the particular post without any adverse remark communicated to him by the at any point of time, petitioner has already got right to be regularized. Thus, a request is made by Siddharth Land Council for issuing suitor to regularize the service of Lord Smith. Then last, in this view of the matter, this court directs the opposite party to regularize the service of the petitioner in the post noted above and grants salary to the petitioner as a regular laboratory technician in par with salary attached to the regular technician pathology in similarly situated hospitals. Since the petitioner will be regularized by the direction of this court, regular salary attached to the laboratory shall be prospective and will be provided to the petitioner from the date of passing of such order. the period of contractual engagement as laboratory technician pathology shall also be considered for counting pensionable service. For the order of court keeping in the particulars the direction so and so. Yes. Let me see the advertisement. Page 26, ma'am. Let's see the serial number 1. Yes. This is laboratory technician. Eligibility criteria, let's see the eligibility criteria. Candidates must have passed LT examination from any of the 3 medical colleges of the state. That was the condition put in the advertisement. Then you'll also see that Honorable Single Judge has relied upon the notification of state government, that is 5/10/2006, where we have provided some relaxation. You'll also see page 36.
I think there's a divisional bench decision of this court that you cannot make regular appointment of candidates not having passed out from these 3.
Here, what has happened?
That is also the not mentioned anywhere.
He does not fall on that relaxed criteria. Let's see page 36.
The question is how are you can just resort now to this objection because he participated in a regular process of selection. You selected him. He was, of course, in number 2 in the merit list. Yes. And since the number 1 did not join, exactly, you have engaged him.
He was wrongly appointed because that I have shown my lord that post was reserved for ST. He cannot be appointed.
Who appointed him?
But that the CDM appointed when it came to the notice of the government, this irregularity has been done. Government director for termination.
Okay.
I'll come to that part only. He's relying that relaxation part, government has relaxed. So in the relaxed standard, he got that appointment. Page 36 is the relaxed standard that 5/10/2006.
Youngster?
My page 36, my
36.
That Honorable Single Judge has relied upon this notification.
Yes.
My para 2 LSMC. Taking into consideration the above aspect, government have been pleased to say that the vacancies in respect of laboratory technician pathology and radiographers which remain unfilled may be filled up from among the candidates who passed out from recognized private institution and have registered their names in the respective provided no from the government or medical. Who passed out from recognized private institutions. Our stand, he has not passed out from recognized private institutions. Even if this relaxed standard is applied, he is not coming within this fold of relaxed standard.
How have you ascertained that the institution is not recognized?
That he has annexed that is the ground in the writ appeal. And he has annexed that document that is not a recognized institution. LRC can find it that he has annexed that document.
Which is the document?
That in his writ petition he has annexed that. LRC can find it page 23 of my writ appeal. Baba Institute of Medical Science and Research.
Your page number?
My page 23, my lord. Let's you got it.
Just a second.
Sorry.
Yes.
And there is no denial to it.
23 is something different.
That's the Bhabha Institute of Medical Science and Research.
23
Looking at
Annexure 2 to their writ appeal.
Annexure
2.
Yes, my lord. Page 23 of my writ appeal, my lord. The certificate issued by Bhabha Institute of Medical Science and Research.
Now
Let's you got it.
This one? Ah.
First of all, he is not fulfilling the condition as per the stipulation made in the advertisement. In the advertisement, 3 conditions are there. But he taking the advantage of the relaxation condition that has been issued on 5/10/2006. And
why this institution, according to you, is not recognized?
That is not that is our stand, my lord, before my lords in the appeal. Because we have not filed counter, so that is and he has not denied it.
What is the question of denying when you have not filed the counter?
That is the stand here, my lord. Then 5/10/2006.
No, whether they have admitted this is not a certificate from a recognized institution.
3 medical colleges are the
No, that is one.
Yes, ma'am.
You have the 3 medical colleges.
Yes, ma'am.
We understand. But at the same time, from other institute also they can get the certificate. It's a question of preference.
Yes, ma'am.
It is a question of preference.
Not preference. If not available, we will accommodate them. That must be from a recognized private institution.
So no, that you have already considering, but your problem is this certificate is not from the recognized private medical institution.
Yes, ma'am. Unless, first of all, here either
but why have you asserted so that this certificate is not from a recognized institution?
The government realized these things have happened in 2012, accordingly directed for termination.
Well, that was brought to his knowledge.
Yes, madam. And this was the subject matter of challenge before my lords, but before Honorable Single Judge in 2012. And that, your lordship, again, I will drop my lordship.
Stand in this matter.
My lord,
whether the institute is recognized.
Yes,
my lord,
by whom?
I will drop my.
One second, I will submit that same annexure 8, my lord. The third para is my learned friend is not reading out. Should I read it? It is at page 24. I'm sorry, 36. Annexure 8. Which my learned friend is harping upon. This is a letter of the Deputy Director to Government, Health and Family Welfare to the Director of Health. Page my lord 36, Annexure 8.
Yes. Oh, this is the same letter.
May I read it, my lord?
Yes.
I'm reading it from the para 1. Due to non-availability of the sufficient candidate from 3 medical colleges, since the basic qualification for applying for the post of laboratory technician, pathology, and radiographer is passed in respective of the courses from the 3 medical colleges only. Then para 2. Taking into consideration the above aspect, government have been pleased to say that the vacancies in respect of the laboratory technician pathology and radiographers which remain unfilled may be filled from among the candidates who passed out from the recognized private institutions and have registered their names in a respective board, provided that no passed out candidate from the government medical colleges are available. Then para 3. In case there is availability of the candidates from both the government medical colleges and private institutions, the first priority should be given to those candidates who passed out from the government colleges. If there is still any vacancies, the remainder vacancies may be filled up from the candidates passed from the private institutions. That is a letter given by them. Then coming to my certificate. So far the page 23, Annexure 2 is concerned.
Yes.
It is a certificate given by the Bhabha Institute of Medical Science and Research under the management of BIEMS registered by the Government of Orissa, affiliated to All India Institute of Medical Technology, Calcutta. This certificate has been duly accepted by them. That apart, my lord, so far my appointment is concerned, it is at page 38, my lord, kind of have a glance. It is a letter dated 19/6/2007.
Okay. Where it is appearing, 2007?
It is at annexure 9 to the writ appeal. It is at page 38. It is a letter of the CDMO cutter to the collector.
Page 38.
Exactly. 19/6/2007. They are marked as 9A as annexer.
Pagination is not there properly, just find out.
After 2 pages of annexure 8,
After 2 pages of annexure 8.
Exactly, which I have read out.
Page 38.
In fact, they have numbered it in double number, so that
That is the problem. Melody was at
2 pages, just 2 pages.
bottom are at 26, above 38. So that is the confusion.
Bottom of the annexure?
Annexure 9, that annexure 8. After 2 pages of annexure 8.
Annexure 8 of the writ appeal.
Writ appeal.
Else you can get it from page 38.
Our record shows only the annexure 7 is there.
Melody in writ appeals.
Page 26.
36.
Date is 19.
Yes, ma'am. Yes, ma'am. That you will also be holding that two numbers are one with 26, just above that 38. So that 26 is it.
Okay.
Wait.
Yes, you now read.
Yes. My lord, I am reading out the para 3, my lord. It is a letter of the CDMO to the collector. Jitendra Kumar Sahu, the present petitioner, is one of the candidate passed from the private institution from LT, Laboratory Technician Pathology. He was in waiting list of serial number 1. Sri Anand Kumar Majhi, LT Pathology, did not join within
that aspect is not under challenge. Their question is now the basic, there is a certificate which that has been given by an institution which is not recognized. That is the issue.
Yes, ma'am. Yes, ma'am. On that one. But since then I am continuing. I am not disputing. Last 15 years. I am not disputing. I am continuing under them.
But so, if you lack in the basic qualification, how the government can allow
as they are saying, but the third para clarifies, which I have read out from annexure 8. It is at 5/10/2006, Milan. In the writ appeal at page 36.
From another writ appeal?
No, madam, from the same writ appeal that I have laid out at annexure 8, 5/10/2006, Milan.
5/10/2006.
Exactly.
That you also have seen that relaxation.
My lords have seen that
this one
available in the tab.
Oh, yes.
That para 3.
Yes.
Priority should be given to those candidates who have passed out from the government college. If there is still any vacancies, the remainder candidates may be filled from the candidate passed from the private institutions.
That private qualifies para 2.
No, private institution means what?
Well, that qualifies para 2.
Then coming to annexure 2 at page 23. That is my certificate given by the institutions which has been affiliated to All India Institute of Medical Technology.
Okay.
And subsequently,
certificate you have seen, only the issue is that whether it is a certificate by a recognized institute or not.
From the government.
from the government.
And it has written that All India Institute of Medical and Technology and registered under the government of Odisha. That has been written in that particular.
Registered as what?
As one of the institution, my lord.
No, registered as a society.
Yes.
That is the whole difficulty, because recognition doesn't come from the register of societies.
And affiliation, my lord, is there, my lord, so far this.
Where is the affiliation by a competent body?
My lord, it is, so far Odisha is concerned, my lord.
Odisha is outside country.
In three medical colleges.
It is the state policy. If you challenge
that has not been implemented in Odisha, and no candidates
but
are
they are
available.
not raising that bar against you. This is already this from the private institution, will accept it, but that must be the recognized institute. But you are not showing any sheet of paper to show that it is a recognized.
Thereafter also, I have given the training successfully. So far, the government training is concerned.
Training doesn't give someone as a basic qualification.
But these certificates are being used in our state because there are no availability of that post in three medical colleges.
This is not the answer. Certificate is unlawfully used by someone cannot be the instance to be cited by you under Article 14. That cannot be done. Unless you can show this your certificate is from a recognized institute or competent to grant such certificate, I think you don't have any case. Because we are very scared now what is happening in these medical institutions, the fake medical institutions. This is a concern of the country also. There are 3 public interest litigation also pending in this High Court. So you have to show that you have acquired that certificate from a recognized institute.
Yes, my lord. Give me 10 days time, my lord, a week time.
Are you ready?
10 days time.
It will come on 23rd of August. No, not it's a week's time is more than 23rd.
And another part, my lord, that even that relaxed standard is also no more because that has been withdrawn.
Okay, just you come on next.
Yes.
Because this is the first issue that.
Well,
23rd of August 2023. The request of Mr. Shukla Mahantil and Council appearing for the writ petitioner respondent. The only questions pertinent to the context is that whether certificate annexure 2 to this writ appeal has been issued by an institution recognized by the competent body or not. So there is no material either in the writ petition or in the records of the writ appeal to get the said answer. As said Mr. Mahantil and Council opinion for the writ petition respondent has asked for a short accommodation so that he can take instruction from the petitioner. So the word instruction will include also any document in support of the recognition. So, Mr. Pantiyo, answers will appeal for the appellant.
Item 31.
Well, in item 31, already notice has been issued.
My lord, may I please, madam?
Yes.
Item 31, I am appearing on behalf of respondent. After notice has been served to me. And today I am filing the Wakalatnama. And kindly allow me a short date so that I will file my counter also.
What counter you will file?
I will file after notice has been served. I am appearing in this case.
What counter in a writ appeal?
I will file my objection, my lord.
Against? Against? IA?
My lord, actually, I do not have the copy, my lord, right now. So,
Right now?
My lord, today my client has sought the Wakalatnama, my lord. That's why I'm not acquainted with the case. I will acquaint.
No, but you know it is a writ appeal.
Yes, my lord.
Writ appeals are normally not required to file any counter affidavit or objection. That is why these questions are being put to you.
Okay, my lord. I will allow me a sort that so that I
You
will
have not
prepare
filed the Bhagalatnama. You have filed this. All right. You have Mr. Panda.
Avakas Nanda.
Oh, all right. But in this Bhagalatnama, your name is there. First, I don't find. Oh, that's it. Mr. Avakas Nanda Learned Council has filed the Bhagalatnama along with his other associates
I'm still trying to get to the
for the respondent stuff. Let the matter be listed on 14th of September 2023. So Mr. M.K. Kantial, additional government advocate, has stated that this order has been passed in a contempt.
Yes, because I have relied upon one judgment of Honorable Apex Court. For that, I have that Midnapur case, your lordship has
I know.
Yes, madam.
Now, this appeal is maintainable.
Yes, that
according to this Midnapur Cooperative Bank Limited, Cooperative, what is this? Cooperative Bank.
Yes, madam.
Some Cooperative Bank, yes. According to the, so there is no question of filing because this issue is settled.
Yes, ma'am. That's and SR has pointed out that defects that is to be ignored, my lord.
copy of the decision has to be given to the SR.
Yes,
They don't point out
I'll sub.
necessarily.
I'll sub.
These that is finally taken.
Registry to submit.
So we'll hear the matter on the next date.
Yes, madam.
On the next date, this matter will be heard and married.
Obliged, one.
Item 32.
May I please?
Before my learned senior starts, may I pray your lordship may call this matter 2 weeks after I may file a counter for the government of India. Opposite party number 1.
For years together, they have taken time. If at all your lordship feels it while hearing, it's a very short point. If your lordship feels their presence, then you'll at that time they give. They know it that they're virtually is not necessary for them, but for some other purpose they have implemented the party. And for years together, they took time.
Now they think they should file. They are praying before the court. You are opposing that prayer.
Madam?
Are you opposing that prayer? They're telling a short time. Want to file the facts.
Let me tell me the facts. If your lordship will file, thereafter your lordship may grant time because
I'm appearing for Mahanari
party. I am for the petitioner, but I don't know the practice is before the petitioner places case, the opposite party interveners.
This is a prayer for adjournment.
No. I am always answering to the question.
Question is, he wants that a particular land.
I want to.
Thus, are you with this?
I'm appearing for Maharaji Coldfield.
You are appearing for whom?
Opposite party number 1, Union of India.
Your lordship can see the orders right from.
Opposite party number 1 is not Union of India. Second case.
In second case.
I am appearing in 12460.
Okay.
Their opposite party number 1 is the
Union of India.
Union of India.
The time they have taken and given for last 2 years, I don't think it is for the necessary. But your lordship may hear me for 5 minutes.
No. If you think that we will not issue any direction of the Union of India,
yes,
we immediately agree.
Yes,
that we will not issue any direction of the Union of India.
No, madam.
So you agree that?
Exactly, madam.
You just be an onlooker. If anything goes against you, then you say that assurance was made by the council for the.
Yes, sir.
No,
it's a very
all right.
The villagers belong with Dhanara. This is one of the biggest villages.
What is your prayer, Mr. Das?
No, I'm appearing for Maharaji Coldfield Limited. Let him place his case because he feels
disturb, let him.
Not, I am not fields. That is
The question is for acquisition of coal area. It is the Union of India who acquire under the Coal Bearing Act, and we are the operating agency. We can't acquire any land, my lord.
If that is the position, it is so because Union of India authorizes them.
State, the state government officers, they acquire, land acquisition officers on behalf of the Union of India, they acquire. So that is why
This is a very, this is a jurisprudence regarding the land acquisition, but it is very clear.
Manner.
The land acquisition collector only represents
Land
the state, appropriate government. But the land acquisition collector, but I don't know, Mahanadi, you are appearing for?
Mahanadi Coalfield Limited.
Coalfield Limited. So for your interest, the Union of India will require the land.
Yes, my lord. It is a coal bearing area under the CBA Act. It is the government of India notifies. Then we operate.
Your lordship, kindly see for a moment Annexure 1. This is the previous land acquisition of the village, whether it's the government of India has taken or somebody else has taken. The village Danara in question is the biggest village in the state of Odisha, is about more than 10,000 population. 88% of the land area has already been acquired by the Mahanadi Coalfield Limited through the land acquisition officer. And the rest 12%, the life of these villagers for last 3 decades, they are very mild and soft people. It's unimaginably mild. And they're only going on for various ulterior fear, going on reputation and asking them that you take this. Last 12% of the land, their life has become hell because of the blasting, pollution, lack of water, all etc. I have stated on detail on affidavits. If your lordship will appoint a commission, if any, because your lordship knows this is a court of affidavits, and consciously this petition has been filed, if any statement is found to be wrong, they are prepared to be punished. But in fact, the counter affidavit says something wrong, contrary to the record or something, they should equally, that officers should also be, their rules should apply both, similar to both. This Annexure 1 will also can see. Rajaswa or Abakari Vibhag. This is not the government of India Abakari.
Okay.
This is the land they have acquired. Is the area, your lordship, Justice RATHO can read it.
No, you want that I should not read it, so I am not reading it.
No. No, I don't know. It's not that one, the government.
My reading, your reading is the same. He will hear it. Please read it.
The land acquisition officer, this has been acquired by the state. So it's not that the government of India is to acquire by notification by authority of the government of India.
On the behalf they do it.
Yes.
State government.
So let me place the facts of the case, which they are now.
Just tell us what do you want.
Yes, your lordship. That is what I was going to say. 5 minutes, otherwise your lordship would have, I mean, by this time, whether proceed or adjourn, it would have been done if my lord would not have interfered. And I pray, my lord, the rules of business should be a little bit followed in a gently, so the petitioner should be allowed to say, thereafter the opposite party should be allowed.
No,
yes.
Just one thing, just I'd like to ask you, because Mr. Mishra, that what the villagers want, because the remaining.
Then I'm 5 minutes.
No, just I'm asking the question.
They want the land which is left out land, as per their own decision, 12%, they should acquire. Because the entire 6, 7, 8 villages.
Very good proposal.
No, the entire 6, 8 villages.
I think it is a very good proposal because it is obvious you are blasting every
8 villages.
Yes,
100% acquired. Please.
Lordship, ask the question, please. I'm not.
No. Just give your lordship asking.
No, I am putting your proposal to him. What is
The question is, I have filed a detailed counter along with a map. Now the coal, there is no coal in this area. The coal which is being excavated now, it has gone beyond 3 kilometers from their villages. We have acquired wherever coal, the government has acquired wherever coal is there. This area is a village cluster having multi-storied buildings. The entire purpose of their siege, if these areas are acquired, they will not only get huge compensation, they will get employment and other benefits. For that reason, they are struggling, not for the coal purpose. And
the villager doesn't have any interest in your coal. They are only interested in their livelihood, clean air, clean water.
Your Lordship, can you see the counter? Counter filed.
Counter, whatever you say, they
No,
say.
my counter. Pollution Control Board has given a counter. There is no pollution problems for them. Pollution Control Board. I am not going to place my counter for the present.
When this report was filed by the Pollution Control Board?
Not report.
Their own observation.
No, they file a mechanical counter. They file a mechanical counter.
This observation is only based on this is a statement made in the counter affidavit.
Yes.
Yes.
Pollution Control Board only made this statement in their counter affidavit.
They have verified, they have submitted an earlier report also.
Well, report is a part of their counter affidavit, Mr.
No, they are not report.
So where is counsel for
Das,
opposite?
Mr. Das is not present. Mr. Das appears for the pollution board, I think. Das.
You're watching the proceedings.
Pollution board.
One question.
Yes, so watch.
No.
When have you filed your counter affidavit?
Annexure 2 will suffice all this below confusion will erase, which is because they are avoiding annexure 2. Their intervention is only because the interference is only to avoid the placement of annexure 2, the relevant para.
Have you filed?
These are all relevant.
When?
On 1/10/2020 in WPC number 12460/2005. Second. Yes.
All right.
Second is the continuation of first. First is the main.
You are referring to paragraph?
I'm
No, where is the mistake?
Pollution Control Board, counter affidavit
Yes.
by Pollution Control.
Paragraph 5 मतलब your submit.
Air quality monitoring couldn't be conducted due to prevailing rainy condition and COVID-19 condition. It will be conducted post monsoon
Yes,
period.
Do you have any report?
Paragraph 5.
What is that report? The counter affidavit, you cannot say such thing. You must have a
Counter affidavit I have not enclosed.
file the report.
Yes.
Because paragraph 5 you are saying we could not conduct the inquiry.
Yes.
If you have conducted, file it. Couldn't be conducted everywhere.
So do you have any report? And Council for the Pollution Control Board, do you have any report? You are saying there is no pollution in the air,
They are not saying also.
No reports.
They are also not saying. This is a wrong thing said by the opposite party.
He was not.
No
there.
report.
What he said should not be placed by the council for the other opposite
I've
party.
said the wrong things. Making a submission is incorrect.
Don't.
Pollution Control Board has given consent to operate to us.
Consent to operate is given. Thereafter, what has happened? We are asking for a report.
I am not a person to make wrong submissions.
Why are you making all these arguments in the court? No, that's not fair.
He is making comments that
He is making an observation and you are answering to that. And when the court is not accepting your statement, court is a different one. Asking the Pollution Control Board whether they have really conducted any
No reports are enclosed. No reports are enclosed.
Not, but whether have you at all conducted any test?
To that I'll take instruction.
Because we have experience whether the public undertaking is applying for, even going to the field, you just issue the consent to operate.
If at all they have conducted any inquiry and the reports were in the
we are fixing that.
Yes, next day the report I'll take.
We want, because you are getting the prior 21 days, you go there, make test of the various part where these villagers are living, whether there is a pollution effect is there or not, and submit the report by the next day. All right.
I stated, if you lots of permit, 300 I have stated, the 100 meters there is no water because there are huge 6 to 7 villages. One second.
Then you identify the village.
No. I have the same village. There are 6 to 7 the cluster of villages. And all villages, this is the biggest village, more than 10,000, probably there is no parallel to this type of village in the whole of state of Odisha. All other villages, 100% land of the entire village has been acquired on the basis of this.
For the time being, this is not our issue.
No, I've got 2 minutes, Malor.
Yes.
One, it will clarify. On the basis of their own equation annexure 2. It's not that the 100% villages who are acquired, the 100% is coal bearing and they do not get acquired. First. Second thing.
Why are you bringing us to your next question? Because we want to see that whether you allegations that it has any scientific basis or not.
No, that is one thing. But the more basis, stronger basis, what I'm pointing out 1 minute. You'll also get annexure 2.
No, we'll not see. What is the stronger basis? Tell us.
Their own decision, where more than 50% of the village land has been acquired, they will make the steps, they will take steps to acquire the whole of the village.
No, yourself saying that this is the biggest village.
No, the 88B, you'll also get annexure 2.
You're saying this is the biggest village.
Annexure 2, page 42. Yes. In case of other villages where 50% of land has already been acquired, it was decided the steps should be taken by MCA to acquire the rest part of the land. And here 88% is already acquired, which is not disputed. And 12% they will say that because there is no cooling there, it is not there. Because of the blasting and the submission made, because of the compensation we made, by 88 acquisition, they got compensation, they got employment, everything.
No,
and when I said
we'll understand. Where is that circular that the 50% land of the village is acquired, the rest will be acquired?
Page 42, this page 34 begins annexure 2 of
which
annexure 2, that is 12460 to
2460, annexure 2.
Page 34 it starts. It's a
so
high level body.
Yes. Which page shall we see?
High level body where the CMD, coal mine, the managing director of the collector, RDC, MPs, MLAs who have become now the union minister now.
Is that relevant?
You're not concerned. You come to that.
Yes, he says in government policy. No.
What is that about this acquisition that 50% if acquired, the later part will be also acquired? We'll come to that clause.
42 mile, last in case of other.
Okay.
It starts from Saja. In case of other villages where 50% land has already been acquired, it was decided that steps should be taken by MCL to acquire the rest part of the land.
All right.
Yes. So on the basis of this, they should take steps. And all in all, when they are given around 65 acres of cultivable land is there, all they are dumping all assets and everything for last more than 3 decades. They are not able to cultivate, nor are they able to go to their land. And when they are, by way of asking, because I rarely do public interest cases in my career without much of a certain effects. When I asked them why you didn't raise this question for last 30 years, keeping quiet, going on giving representation, you continue to give representation for another 30 years. Then they said that because the people, 88 for acquisition of the 88% of the land, each family members got the employment. If they agitate more, they will take the only thing you must know the state and functionaries by initiating proceeding or transferring them. So apparently transfer, they did not raise serious objection till today. And for last 30 years, they are not getting water for 300 foot, 100 meters. Let the pollution board give a certificate that water is available. And only 12% of the land and the houses below most of the houses, you'll also kindly send a commission of any competent person, is cracking because of the blasting in the whole of the area. And the CMD himself was present, and in the counter, they have not said that this resolution has been overturned. And this has been given with a great reason by taking the presence of various persons. Various MLAs, MPs, etc. CMD, the number 18, page 45, chairman, the managing director, this MCL, land acquisition officer, collector, RDC is presented by the RDC. So this is their own decision. And why this type policy decisions are taken, Manu? If in 50%, this the excavation goes for the coal building, is it possible for the part of the other people to live with the dignity of life? That air, water, and sound. So the whole, that is the reason.
Mr. One question is traveling through mind. I have to share with you.
My lord.
There is a kind of an advisory committee. They are suggesting the government or the authorities to, in respect to the rehabilitation, whether they have the authority to declare such policy decision or whether any court should rely on such policy decision taken by the advisory committee.
It is not because they fight taking into consideration.
Mr. It is a fundamental question. Who will you provide them finance? These authority will decide whether they will take. Because the policy decision is that others taken, we do not know. This is the similar steps may be taken.
Yes.
Taking steps is one thing and direction to acquire land.
Exactly. That is what you also decides. That in the whole of the 6-7 villages where 100% lands are acquired, including the village in question where 88, and there are 2 villages where they have taken 80 or
because the land is acquired on the basis of the requirement. That why you are acquiring
not the requirement. This decision, this proceeding has been taken because
proceeding by only an advisory committee. Even their recommendation may not be accepted.
I don't dispute that, my lord. So it's all possible. But what the point is that the person who takes a decision, that because there is a basis. And what is the basis?
This is in other case 50% that was taken.
No.
That is
no. The rest is 100% taken. They say 50% because in the minor activities, the rest 50% life will not be feasible to stay. That is why they taken the ground on this ground. They have taken.
All right.
That is the reason they have taken. And you also just the entire 60, I have stated in my affidavit petition, around 7 to 8 villages are there, where out of all, 100% they have acquired the land, including houses, buildings, 3 stories, 4 stories, etc., etc. Only 2 villages where they could not give remuneration for 10 to 12 all residents, they have allowed to stay in their houses. 2 villages out of 7 to 8. And this is another village where 88% is taken, and they have not taken this one. But the other person they have taken, but allowed them to stay in their house.
So clearly there are 2 grounds you are taking.
My lord.
Number one, since the 50%, this is the recommendation is there.
Because it's impossible.
And for this, you rely on the recommendation of these advisors.
This is their own, in presence of their own bodies, people. Proceeding, Regulation and Peripheral Development Advisory Committee of MCL. This was their own decision, and this decision has been
of an advisory committee.
No. Yes, advisory committee. This decision they have taken on their own reasons.
That will be accepted. The recommendation made. It will be decided.
I will take a decision.
It's not a policy decision. This is a suggestion for the rehabilitation. The second is that this area, the villages are affected by the pollution.
Pollution, sound pollution, air pollution, and lack of water. And is a danger to life. This washing machine, blasting, transportation, thousands and thousands. Is the coal mine faced British area more than 100 years. And the highest temperature in my childhood we are finding, the highest temperature always in Orissa is Talcher. Now it is shifted to various other places of the state because of the climate change. But in so far, if you also go back to 40-50 years, that was out of 10 years, 7-8 years, Talcher is the highest. And because of the huge coal bearing areas. And if you also send a committee, if this is physically possible, humanly to read it,
committee will direct the.
No, I said that if it's humanly possible to live there.
Because it is their statutory duty. If an allegations comes to go there and inquiring, the standard of air, standard of water, because under the 2 acts, Air Pollution and the Water Pollution Act, there's the only authority who can conduct the scientific investigation.
And there is no water. So 100 meters, you don't get water because they are pumping.
All right. First, ask them to just.
I understand. I wanted to show this.
All right.
This their own decision they have taken with the reason.
This is a recommendation.
I understand. Recommending themselves.
Decisions.
My lord, it's a recommendation themselves.
No, the advisory committee by
themselves.
Yes.
The person who needs it.
All right, we are not going this. We are
asking the because they themselves the CMD was present.
All right. But Mr. H.S. Mishra and Counsel appearing with the petitioner. According to Mr. Mishra, the village, namely Danara, is affected by the mining activities So the air standard in the village has become hazardous, and no villages cannot expected to live in such condition. So, Mr. Mishra has also stated that even though what standard of the water has changed, the water level has gone down
100 meters
by 100 meter after these, say, mining activities have started. But before us, there is no scientific data based on which we can accept such statements. Mr. Mishra has also agreed that scientific investigation should be made in order to guarantee the safe life to the petitioners. Stop. We find sufficient force in that submission. As such, we direct the statutory authority who is supposed to monitor the air standard and water standard under the pollution, just check up, pollution of air act and pollution of water act. So,
sound pollution.
To make a scientific inquiry of this village, it is under
district of Angul.
Under the district of Angul, within a period of 21 days from the date of receipt of a copy of this order from this court, we make it absolutely clear the State Pollution Control Board not only submit a report before us, they also submit the scientific data based on which the report has been prepared. Stop. Let the matter be listed again on September 2023. So the report shall be submitted for consideration before 31st of August after supplying copy to the council for the parties.
Not a free copy, maybe.
We are directing a free copy of this order be granted to Mr. Abhishek. You are
G. Mohanty.
G. Mohanty. It is typed at Abhishek Mohanty. G. Mohanty, Leonard. Council appearing for the opposite party number 4. All right.
Map submit on that. Including sound pollution and including sound pollution and air pollution.
All right. Sound, air, and water. Just making this.
And one thing, my lord, if your lordship please, the collector will be directed to get a report from the concerned RTO, MBI or anybody. What are the number of trucks loaded with the coal going through that village area per day? Thousands.
All right. That will consider the report first.
My lord.
Other matter. Remaining matter will be called out after break.
In 2017, the Archaeological Survey of India, my lords, went in for a change of policy for regulating the, my lords, entry of photographers into Konarak temple for the purpose of taking photographs of tourists and making out a living of their own, not as if they're earning thousands of rupees. They're just taking some photographs and whatever they earn through in a day, my lords, that's their entire earning. Now, per se 2007, there was a policy. The Lordship may kindly turn to page 27. of the writ appeal. This is the subtle change. Page 27 of the writ appeal. This was the 2007 policy. Any photographer, Lordship got that bold. Any photographer who is a citizen of India.
This one?
My lord, writ appeal 81 of 2022. Page 27. Page 27. Yes, I've quoted it. I've quoted it.
Just give us a second. Yes.
No, page. Yes, writ appeal 81. Minutes after the cost at
21.
47. Page 27.
Next one. Digital is 80.
Looks like this, Malad. This page looks like this.
All right, got it now.
Malad. Any photographer who is a citizen of India and not below 18 years of age and possesses the requisite skill and expertise to operate a still camera shall be eligible to apply for a license for photography. The applicant for a license need not necessarily own a studio. Now, this was the condition. Manage for issuance of the license. But Manage, this is only a watershed line. These people have been working for more than 2 decades. These people. Then Manage 29, page 29. In 2017, Manage, they come up with a new rule. That triggers the cause of action. Eligibility conditions. Purportedly, the rule has been framed under Section 38 of the Archaeological Survey, powers under Section 38 of the Archaeological Survey of India Act.
8.
They now introduced, Rule 8. Now they introduce an educational eligibility conditions wherein they prescribe educational qualifications. Matriculation or 10th pass and 1-year diploma in photography or 5 years experience in photography at tourist places. Now, this directly led to the cascading effect of this was that none of these photographers now qualified excepting 5 or 10 who had.
Because you are saying they are doing it for many years.
Yes, 20 years, more than 20 years, Now, when we came to
because of the educational qualification,
now they're being eliminated because that is it, and
because of the educational qualification.
Yes, the insistence on educational matriculation.
But is it insistent? There is or I think.
No, comma.
No, that or is for 1-year diploma in photography or experience. Matriculate or 10th pass is mandatory.
Is mandatory. Right. See, or is for that. Diploma or this thing.
Okay.
Is appearing for the Archaeological Survey.
Yes, we are appearing.
I'll just
Mr. just a moment. Those who are already working there, their educational qualification requirement should be waived. For the new entrants, you impose it. We will not do that. Right? Because they are making their living. Just think of that. Those are already licensed by the earlier eligibility. Their educational qualification will be waived. Right? But for the new entrants, you impose it. We have no difficulty.
I'm just clarifying for a moment.
Yes.
What happened in this case, what my lord is saying is it is quite natural because those are
quite natural. No, this is
but yes,
it's not human.
Only thing is this.
some persons, they don't have any sort of license.
No, don't allow them.
That's why this single judge, honorable single judge, passed an order. The state government should give a tourism department should give a identification based on which the SI can recognize who are the photographers. Because in Konark, hundreds of photographers are running.
This site is completely controlled by the ASI.
Yes.
We will not involve the state government in this matter, right? ASI will determine according to their rules. But those who are already enjoying the license for all these years, for not having the educational qualification and don't suspend their license, allow them to
those persons got the license.
Yes. You hear him and then respond. Yes.
But those persons are already got the license. Earlier, we definitely will allow them.
All right, that's all.
I'll place your lordship's earlier order. Order dated 28/9/2022. Lordship may kindly order number 12. Lordship's earlier order. I'll take a little bit of time from your lordship minutes. I hope your lordship grants me the time to place the entire order. So the entire dispute matters have been encapsulated here. The appeal raises the issue concerning photographers at the Konark Monument. Some of them have been photographers for over 3 decades, but do not have the minimum qualification or matriculation required under the policy framed in 2017 by the Archaeological Survey of India for grant of license. As a result, the 154 appellants who had filed writ petition civil bearing so and so, which has been dismissed by the impugned order of the learned single judge, find themselves out of reckoning in terms of the 2017 policy. It must be noted here.
That is, it is not required to read the entire order because.
No, I'll come to the minutes, only the operative portion, paragraph 7.
Paragraph 7. You have read this paragraph 7 already. Come.
That is it appears to be a genuine concern and it undoubtedly affects the livelihoods.
Exactly what you're saying.
That is.
Exactly what.
So my learned friend is insisting on the expression license. It is it's identification. Permits issued by the tourist department.
Because your case
110. That is where the catch.
This is the crux, my lord.
That is the
whoever are coming,
so
they're coming.
My learned friend immediately agreed. Immediately agreed to the license. It is. so it was very convenient for him to say yes.
10 persons are fulfilling the intervener.
10%, and now they say that accepting us 10, everybody else should be thrown out. Their intervention is for that purpose.
No, but on what basis this 154 are doing? Since when?
They are doing it by the identification issued by the tourist department.
We have received a communication.
Tourist department has never issued any identification.
I think that they have not issued any.
Tourist department has never issued any in favor of any person.
Rather this.
Please, Mr.
Only don't talk together just one by one. Yes, Mr. Mudali, what it is. Only just take note of Mr. Palit, what Mr. Mudali is the.
I'll respond.
It is better for you.
That is there in the record. My lord may kindly see.
You have a counter affidavit?
No, I don't have any counter affidavit. I am placing the document which I filed by my learned senior. And my lord can see IA number 3731 of 2022 at flag J.
IA number
3731 of 2022.
Yes.
That is at flag J.
Yes.
There, my lord may kindly see.
Page.
Who has filed this application? Petitioner?
The petitioner. Appellants. There, my lord may kindly see internal page 26, annexure 8. May I place my lord?
Yes.
This is the heading is minutes of the meeting held on 3/11/2022 at 3:30 p.m. under the chairmanship of ADM Protocol Puri to discuss on implementation of the Honorable High Court dated 28/9/2022. This is regarding implementation of the interim order passed in WA number 81 of 2022 arising out of WPC number 17384 of 2015 disposed of on 5/11/2022. As per the verbal instruction of Collector Puri, a meeting was held on 3/11/2022 at 3:30 p.m. under the chairmanship of the ADM Protocol Puri to discuss on implementation of the Honorable High Court order dated 28/9/2022 passed in writ appeal number 81 of 2022. That is the present writ appeal. Now, my lord, may kindly see the order has been quoted. Last but one paragraph. The line starts with the representative. The representative of the Photographers Association, Mr. Ashok Kumar Swain, that is the present appellant number 1, requested that they had been issued identity cards by the then tourist officer Konark. They don't have the identity cards issued by the tourism department. Well, my lords have directed that those persons who have been issued the identity card by the tourism department, they will be allowed. But these persons, including the appellant, they don't have any identity card issued by the tourism department.
But your one tourism officer has issued the identity cards.
Yes, that also. No, I will produce all those documents which I will file my senior as well as by the intervener. I will produce. The authenticity of those documents are also now in doubt because copies of office copies are not available. Yes.
And there is no letter authorizing him.
Yes. He produced a letter number so-and-so dated 7/2/2008 of Director Tourism addressed to Superintendent of Archaeology, which inter alia mentioned about the issuance of identity cards for 110 numbers of photographers, enclosing their list and receipt of applications of another 45 numbers of photographers. For issue of identity card by the then tourist officer Konar. Basing on this letter, he requested to allow the members of the premises of Sun Temple for commercial photography. The tourist officer Konar present in the meeting informed that the copy of the identity card issued by the then tourist officer is not available in his office, and any order of the tourism department authorizing the then tourist officer to issue such identity cards is also not available in his office. In such situation, the authenticity of the identity cards issued by the then tourist officer Konar cannot be verified at his level. The Superintendent of Archaeologists ASI Bhubaneswar produced a letter number 8298 dated 1/11/2022 of Assistant Director Tourism Department, wherein the Tourism Department has informed that no photographers have been granted identity cards by the Tourism Department for carrying photography business at Sun Temple, Konar. In view of the above, he apprehended that allowing the photographers basing on the identity cards issued by the then tourist officer Konar, but not by the tourism department and whose authenticity cannot be verified, may violate the order of the Honorable High Court. So accordingly, we have not allowed the appellants.
No, actually,
they don't have any identity card issued by the tourism department. Now, the next document I will place. That is, that document, my lord, will find. Well, here an affidavit has been filed by the interveners that is available in flag Y.
That is there also, they have quoted that part.
And by the said thing, have you limited the number to 68?
78 is the number fixed.
Fixed, 78.
For all India, 3,000 monuments, everywhere number is fixed. Now 300 people are entering in the name of photography.
My lord is rightly said that apart from 10, 60. Yes.
Apart from, yes.
Out of 78, 10 is there, 68 is useful.
And if they are relying upon this 2007 circular, they should get as per the 2007 circular.
17. Even prior to that, they were there.
Earlier one. So that they can see the entire document, annexure 1 of the writ appeal.
May I suggest one thing? Just a minute. What I am suggesting? What is the, some people's sentiment is there, some people are getting their bread and butter there.
That is the issue.
So what I'm saying, my lord, let a committee be constituted, a press. Those 10 persons are there, it is fine. Apart from this, basing on our notification, those are basic qualification. Let them have an examination. Their on basis may be fixed. Basing on which
anxiety somewhere else. It is not the new entrant. His anxiety, those who are now living.
Now, yes. Yes, they're working since long, even though they don't have a license. And now tourism department saying that we have not issued an I card. So we are also helpless. Unless until there is no specific identification, those are working since long. This officer could not find out that who is a newcomer, who is a old man.
That issue was addressed by your lordships in the earlier order. That issue was addressed by your lordships in the earlier order.
Interim order.
Interim order, paragraph 8. Mr. Mudali, just 1 minute. Paragraph 8. It appears that during the pendency of the writ petition, number so and so, an interim order was initially passed by the learned single judge on 29th August 2017, stating that the petitioners who have been granted license by the tourism department shall be allowed to perform the duties as professional photographers till the next date. It appears that the said interim order continued throughout the pendency of the writ petition. It is now explained that although the expression license was issued, what was meant was the identity card issued by the tourism department, government of Orissa. It was on that basis that 154 appellants were operating as photographers in the monument. It is only after the impugned order of the learned single judge was passed on 5th January that they have ceased to operate. Since it's a question of livelihood and considering that they have been functioning as photographers, even during the pendency of the writ petition, on a balance of convenience directed subject to the ASI and district administration regulating the entry of the appellants to the monuments on the basis of the identity cards issued to them by the tourism department, only those appellants possessing such cards will be permitted to operate in the monument until further order. What they are saying, that tourist officer may have issued, but he has done it without any authority. That is their entire
We do not know what is the standing
entire plan.
Officer.
So, I will also take instruction. If we are given the liberty to apply under the 2007 rules,
that yes,
that would also.
That was I'm thinking.
Yes, just to
7 rule.
Yes,
among these petitioners, would be granted the license
without discrimination.
That suggestion.
I will just take instruction.
For the interest of justice, I may be permitted to assist my lord.
You are for
I am for the petitioner in the tied up matters. Your lordship's query answer is in my synopsis, my lord. It is very categorically it was answered, my lord. I may be permitted to take your lordships to 11595/2023. The second read.
Prior to my friend goes to the other writ petition. This writ petition only your lordship can the impugned order at page 67, paragraph 1. In fact, the petitioner they have already applied on the 2007 policy, and that is pending. That is their case.
Yes.
So that should be disposed of by the ASI.
Without insisting on a matriculation certificate. Without insisting on a matriculation certificate.
2007 policy, there was no matriculation.
No matriculation. Without
that is the line.
Fully.
If my lord permit me, 2007 is not at all a policy. It is an advertisement for 3 years arrangement. That my friend is not bringing to my lord notice.
Because we are considering it as a policy.
No, my lord,
I know it's not a policy, but we need some standard to come out of this problem.
But that has been throughout India,
I'm a little surprised that my learned friend. We are not
even side of this problem.
I'm not against my learned friends. 10
what difficulty we are facing? We have been selected. They are taking each year 25,000. That is not the issue. Now the 300 person that they are coming up, they are straight away preventing us. You can't be allowed.
That's a false submission.
That's what I'm before my lord.
No, that's a false submission.
But each day FIR has been filed. Your lordship kindly see me.
That is the reason we interfere. Otherwise, we have no business to interfere in the.
Let the number be fixed, my lord. Let the number be fixed for 78. For it is already circulated. 78 was since last 10 years. The number is fixed, and 17 it was again reiterated for all over India. Each monument there is a fixed number. Now your lordship will find if anybody goes to the monument, the number of photographers are 300.
Only the 10 persons are the new licensee.
They are licensed in 25. They have conducted 3-tier interview. They have taken each year 25,000, my lord. Now we are not able to conduct photography because of 300 people are obstructing us. No, we will not be permitted. Each day, my lord, they are filing FIRs.
That is why we have
let the number
situation.
But let the number be fixed, my lord.
And the order should be resolved between the parties. The matter should be resolved amicably, not that
But if it is a question of
What your lordship suggested on the last occasion, what your lordship suggested on the last occasion was this, that an affidavit has been filed on this aspect by the ASI before the next date. If there is a concern from the side of the ASI as to the maximum number of photographers that can be permitted on a daily basis in the monument, then a system of rotation could be devised to limit the number and permit the photographers. It is made clear that the above policy changes, if accepted by the ASI, will not affect those who are already granted license under the 2017 Act. So your lordships have, after full length hearing, your lordships have applied mind and already devised
Why is the petition pending?
for them, it was there.
From which order?
This is the order of your lordships, manage dated. Order number 12 in the writ appeal. Order number 12 dated 28/9/2022. Full blown hearing was conducted. My learned friend was heard. Everybody was heard. And then your lordships, after my lords complete completely hearing all the sides, my lords, lordship devised a reasonable.
This payment of money and everything will equally apply to your clients also.
No, that is all right, my lord. That is all right. That is all right. My matriculation certificate is something that is standing in the way, my
all right. Because the rotation suggestion also very important.
My lord,
but I don't know.
Very reasonable suggestion, my lord.
What is unreasonable is the 25,000. That will also direct the ASI to reconsider the matter in view of our order. The number will increase.
My lord, with regard to 2007 is concerned.
In fact, the charge is too high.
No. If
By the question.
limited number would have been there, would have been all right.
He says
My personal experience in the field, they're charging too high.
Too high because people are taking photographs with phone. They don't take their services. That is why what will they do?
Photographers for two, this mobile cannot fulfill their purpose.
They are able to do.
Photographers definitely have a legal process.
What it is for 3 years. Yes. Then 2017 is coming. Those are submitted their application. I don't have any.
Understand.
Suppose 10 is there on the record. Suppose some people are applied in 2007 also. So we have make according to my lord's suggestion. Let them make a list. Who are the persons that applied in 2007?
No, there is no question of applicability because of the wrong approach taken by one tourism officer. They did not apply, perhaps, most of the cases.
No, tourism officer is a different, my lord. In this ASI,
we will only restrict this relief to the petitioners before us. Those for the world, we have no concern for the world.
What ASI, what regulations come from what? It is for all over India.
And the authenticate list of photographers are before your lordships and marked as annexure 2 of the writ petition. The last writ petition, my lord.
81.
That is the number is 11598 of 2023.
I have not verified that list.
Why is that list authenticated? Who has given that list?
Yes, madam. In the year,
Who has given that
I will be permitted to ask. I will answer, my lord. In the year 2019, during FONI, the Commissioner Tourism Department directed the collector to inquire into the matter how many photographers are working in different monuments. The collector had given a report, which I collected under RTI
33.
That is 11598 of 11595 of 2023, my lord. Annexure 2, my lord. And Annexure 3 says I have filed the RTI information, which clearly shows that 110 persons who had granted that identity cards and 271 members of photographers got financial assistance worth ₹10,000 from the state government. They are working on that date, my lord. And my lord's observation is that those who are continuing photographers, they may be permitted to allow. Then I want to take
your writ petition number. That is
the last writ petition, my lord.
That means your writ petitioners are an addition to the appellants in the writ appeal.
They are 110 in numbers. We are around more than 200, my lord, in 2 separate writ petitions. We are doing photography. We are protected by the Honorable Single Judge. But when I bring it to the notice of the Honorable Single Judge that this writ appeal is there, after going to the writ appeal, Honorable Single Judge delisted the matter. And here in this writ petition, we are challenging the 68 numbers of photographers because the footfall is very high.
This petition is only 29 petitioners. The last one.
The last one is 29, my lord. So all other writ petitions are also there, my lord. Other councils are appearing. Here, my lord, first read we are in number 45 and second is 29, my lord. Writ petition is listed, my lord. One is 11595, another is 11560.
And Mr. Paul, how many petitioners are you representing?
In my writ appeal, my lords, we are 154, but 110 is.
That is self-lead case.
I am for 154, but 110 is those who have the cards.
Their card list is also under RTA information running page 23, my lord. And with the 271 financial assistant is at 25.
That is the claim. Now the writ petition is in the writ appeal.
We are also protected, my lord, but later, my lord, we have given out of 25,000 rupees, our case was considered and we are allowed to give 5,000 rupees. Then the ASI allowed us to doing photography inside Konark Sun Temple.
Licensee 25, unlicensee 5,000.
No, but we are but my lord, after this writ appeal order, we are not allowed that 110 numbers only allowed.
No, it's all right.
So, my lord, my humble submission is how that these photographers are doing photography will be taken into record. This collector's report at.
So the total number before us is now very clear.
Yes, my lord.
It is 224 only.
Yes, my lord.
Maximum permission limit is 70.
But the maximum permission limit
here, my lord,
78. Maximum 78 persons can be accommodated
per day.
For license.
As a license holder. So, per day, yes.
Not per day, my lord. Enters.
You routed that 78. That 78 person will be routed all over this monument place. It is not that that was exactly 20 may participate, 30 may participate.
That was exactly the intention of your lordship. That a rotation policy can also should be introduced in order that if there is a spillover, so that everybody gets a chance to account the livelihood.
Document regarding the funny this.
Yes, madam.
No, that here I don't have a copy.
Well, what time of funny? They might have requested the collector.
Yes.
And the collector
another in entire.
Just a minute. They have wrote a letter to the superintendent of archaeology. We have filed an affidavit in this regard. Customer find this writ appeal affidavit, additional affidavit. We have annexed the document.
Where?
That was additional affidavit. The document has been annexed.
Flag Y. Flag Y. Lordship may see the R/3 onwards. It is coming under the
R4. R/4. Page 24.
Page 24.
This
No, this is the additional affidavit filed by
filed by the ASI.
ASI. Central government.
Yes. No. ASI is a opposite party. Respondent.
Why by the interveners?
No. Why? It is flag F.
Some superintendent archaeology person.
Flag Y.
That is flag X.
Sorry, and then we have made mistake. Superintendent. In that it is X. In that affidavit, let's may come to the page 24. Page 24, R/4. Paragraph 6 we have mentioned, it is internal page 3 onwards. And it is reflected in page 4 of the additional affidavit. And running page 24, internal page 24, running page I didn't have my lord, sir.
Here only we are getting only 110 names.
Yes, that names are being forwarded by the collector, by the tourist officer, CORAM, on 4/1/23 to the Superintendent Archaeology. This in return, yes, in their press read, they have annexed this document.
Those are
Yes.
also found to be unauthorized. Subsequently found unauthorized.
My lord pleases to go through the document of the tourism department, that is in my read petition, my lord. 11595/2023, annexure 2, running page 22, my lord.
So this question is coming. Whoever may be, whatever circumstance, the I card has been issued by the tourist department or not to issue the tourist department, but they are working. And officially, those persons have been given license. They cannot be ignored because they have authorizedly, competent authority has issued the license to them. Those persons are unauthorizedly coming, or they are fighting each other that we are the photographers, we are not been recognized, or minimum qualification is required such we don't have, so we cannot throw out.
We are asking them to give the license. No, that 2009 was they working with this.
Friends are challenged. Other writ petition orders still staring at them. Without license, nobody is permitted to enter in. That is hard analogously. That is 25176 of 2021. They have participated. They have not challenged, my lord.
Justice
Sinha's order. Not challenged yet. That is, your lordship kindly have a glance to my additional affidavit I have filed, page 38. They have participated. Their names are indicated, Mr. My lord. Here are the original writ petition. The licensee photographers filed second one, subsequent one. Both the matters are hard together. 2 orders are passed, my lord. They have participated in that subsequent writ petition also.
Where is the reference of
Page 38, my lord, of the additional affidavit filed by the interveners.
In which
Annexure E, in the writ appeal.
In which writ appeal? The still
In the 81, my lord.
81.
Only writ appeal.
Annexure?
Annexure E, my lord. To the interveners.
Flag Y.
Flag Y.
Affidavit at flag Y.
By the intervenor. Internal page 38. It I mean you take up the license.
At page?
At page 38, it starts, my lord, relevant portion. Learned single judge, yes. Learned single judge has quoted the provision. And the paragraph 4. Reference was also made of that writ petition, which my lord senior challenging. Para 4.
Affidavit taken.
Seven is input. Yes. It will appear that the interim order based on the opposite party, including the
Internal page 40, paragraph 7 is read.
But the Ashok Kumar Swain is challenged.
Ashok Kumar Swain is challenged.
Yes.
Yes. Para 4.
Our direct read which was turned down, that has been challenged.
Mr. Marana, the learned counsel appearing for them. Appears on behalf of the applicants who wants to intervene, they submit. Their clients are applied for license under the old guideline. They are writ petition, WPC number so and so. To dispose of this day, these clients are enjoying interim order in that writ petition, that their clients made operative till 6 weeks. It is pursuant to the interim order. Their clients were entering into presence of the protected monument to take photographs and their livelihood. They will, in the meantime, they will apply. This was the direction. They have, some of them also applied. Apply for issuance of license under the new guideline. On query, from court, Mr. Guru submit. His client take photographs of visitors who will visit the Sun Temple. Mr. Sharma, so and so. Let's you kindly come to the next operating person. for purpose of ascertaining so and so, Ashok Kumar Swami Supra, permitted to, in contravention to the rule, it is necessary to, the interim order has been quoted. It will appear the interim order based on so and so opposite party, including the administration, will ensure the all persons for entry.
Their interim order passed by the same single judge?
Same thing.
Yes, madam. It was continued for 6 years. You'll also kindly see the next page. It follows that apart from the tourists, only those who have valid license, this is now they are not challenged. Valid license for purpose of conducting photography in persons of protected monument are be allowed to enter. This must be complied to the ASI in assistance to administration. So this is not, they have not challenged. Without license and under the new guide rule, they have never challenged it. They have participated in that repeats.
That order was managed subsequently.
But since because the policy decision,
division,
so they run it,
your lordship's order in the division bench manner that took over the situation thereafter. And there was a direction to the.
This policy was implemented throughout India. 3,600 monuments are being regulated.
The specific question was what is the
the position of law is very clear so far as policies are concerned. It is implemented since last 7 years. And we are now the ultimate sufferer because of these unauthorized entries.
So only 10% will take for
that is not a
first in the present appeals. Its direction with those follows, only those persons will be allowed inside the premises to do the photography who are having the license.
Having the license.
It is rules provides that.
Yes.
We cannot change the rule.
Yes.
We are concerning how the rules can be a little rationalized to accommodate some people to get the license. They will also not provide, without license, they will not also not.
My entire submission, the original challenge in the repetition was that 2007 advertisement. It was not a policy. That was for 3 years. Subsequent also, they have not challenged this policy, my lord. 17 policy, which was never been challenged, my lord. Only that 7 years. In 2007 advertisement was challenged, which was made for 3 years. They have quoted only 7 clauses. 8 clauses was very important. It was for 3 years. That they have challenged. It is now become infectious by epochs of time, enjoying the interim order.
Just listen to me. Suppose some persons were granted license for 3 years and they were continuing that.
And not even granted, they have to apply.
That's the political situation. Try to understand the logic behind it.
Yes.
They were given at that time, there was no imposition of the matriculate or anything. So these people will be continuing, and we do not know, maybe the other people who entered into the same business, right? In 2017, you have given a very stringent rule, matriculate, diploma, and 5 years experience. First of all, whether we want to know all the petitioners have that 5 years experience or not, and how they have proved it.
Yes, madam. That document is with me, madam.
All right, wait. So we are thinking that those who have the 5 years experiments and doing in the same business inside the corner of Sun Temple before 2017, in their case, this matriculate educational qualification should not be insisted upon.
Bow down.
Because why I am telling you, they have an existing right of continuing with the license. And it is always everywhere, when the act cannot be given a retrospective effect. But what point you are telling that they were never also given license under 2007 rules.
Yes.
That is why our buck stops there.
Yes.
Right. So we are trying to find out a reasonable solution. That is why. Because otherwise, whatever rule there will be chaos all the time.
Yes, exactly. That's not happening, madam.
That is why you rationalize the situation. Rationalize the situation.
Yes, madam. I only concern to the number should be stipulated. Not to, as your lordship has rightly indicated, there will be chaos, madam. It is now being a chaos. It is the report of the ASI.
So that is why what I find tentatively that there will be 10 licenses are there, and total petitioners are 224.
Yes, ma'am.
We will not consider any other person beyond that who are just sleeping on their right. If they had any right, we have no concern.
10 are already protected.
No, 10 already got the right.
Already got protected now. They are beyond the of any dispute.
This comes to about 234, 35.
Input them 110 plus 1.
Oh, no. 29, 41.
29, 41, 110.
SI can give the license only 78. 10 is there, only 68 will be given. not more than this.
That number, that magic number was challenging, my lord, basing upon the footfall which we got under RTA Act. That is a prayer in our writ petition.
That was all right. All these are falls within the domain of the policy court are not
Yes, ma'am.
necessarily
That
have
is
to be
policy.
said. Even the court indicated to rotation basis.
Yes, my lord.
That is the reasonable.
Only to assist my lord.
That is the reason.
Much was said that 2007 was an advertisement, not a policy. That my lord, we can see page 40 of the writ appeal.
That we have seen once. Again, we can see.
Page 40, annex 1. The facts should be clear, man.
For 3 years.
In the memorandum of appeal, you are referring to.
Yes. For issue of annexure 1, issue of license, guidelines for issue of license to photographers to operate precincts of central.
Heading is Government of India Archaeological Survey of India guidelines for issue of license to photographers to operate within the precincts of certain centrally protected monuments. The question of revision of guidelines for issuance of photograph license for operating in protected centrally protected monuments of the Archaeological Survey of India are under consideration in this office for some time. Now, a final decision has been taken and the following guidelines are issued which will be applicable for issuance of licenses to photographers for operating in the centrally protected monuments with effect from 1/2/2007. So this policy came into effect from 1/2/2007.
1/2/2007.
So the argument that this is an advertisement.
No, this is not an advertisement. It's clear guidelines.
By no stretch of imagination can it be an advertisement.
No, by the intervener, they are saying that.
Yes, they are saying for their own benefit because it suits them.
But in that also policy, there is no the number of the license.
No, there is no.
Why are you getting the 78?
Number is yes, my lord. That I want to assist your lordships. That is in my writ petition, my lord. Only on an advertisement, the number they reflected is 68.
Well,
yes, my lord, I'm taking a lordships. Yes, my lord, in my writ petition, that is WPC number 11595 of 2023, running page 52, my lord. It is only said notification only the number is 60.
Your writ petition is 17384 of 2000.
No, my lord, it is 11595.
Your writ petition, okay.
Yes, 11595 2023. Running page 52, my lord.
115958.
11595.
Page.
Running page 52, my lord. This is the only document where it is reflected that the number is 68.
It is annexure.
It is, my lord, it is part of annexure 51. Page 51, annexure 7 series, my lord.
Okay.
The relevant page is at 52.
This is a form of a notice.
Yes, my lord. It is a notice. After the first paragraph, it is written as per extant policy, number of the photographers for license is restricted to 68 in numbers.
Policy is there.
What is that policy?
Yes.
Let them show because they have held it in policy.
If lordship want, then I will produce it. There is no.
And my lord, despite the judicial order, she had not sought
the single judge.
No, I understand. But how do you get this number 68?
Yes, my lord. From where they get this magic number?
It will be produced, my lord. We can get it from the department.
And my lord, one humble submission, my lord. Even if your lordship's judicial order, they have not supplied me the copy of the affidavit. I have requested Mr. Pradhan, but till date he has not supplied me the copy.
Supply
is very unfortunate. Read. Kindly have a glance to the order. My lord, the order dated 17/5/2023.
This order was passed in the appeal. Yes. But it has.
This judicial order is, my lord, 17/5/2023.
Which copy you got?
Sir,
ଆରେ କୋଉଟା କହୁନ କଣ ଦେଖିବି ପଚାରୁଛୁ କଣ କପି ପଚାରିଲେ ମୁଁ ଦେଇଦେବି ପଚାରୁଛୁ ମତେ ଦେଖୁନାହାନ୍ତି I am giving the My lord, may I keep it to some other day, then I'll get the instruction about this 68 or policy. Then it will produce with the court. As well as you will take the about the, if necessary, then you can file the affidavit in this. My friend
No, affidavit, 30th of August, you are fixing the matter again. Take the instruction for 68 because,
my lord,
because we have to see whether that can be increased in under the rule also.
Yes, madam.
Before we use our discretionary power, if it is not permits us by anything, by any authority, they can give the direction considering the situation to enhance the rate. Otherwise, we can think of the rotation policy.
That the honorable single judge also observed the same.
No, it's all right, but you have to pay 20.
Yes, madam. That 25,000 license fee.
Whatever license fee is there, they have to pay also.
No,
should put on in the same platform. Because this should be brought to an end.
No, this dispute has to come to an end. Is it question? That area.
Under 2007 policy also 5,000 was there.
5,000, 3,000 and 1,500.
That money we are not going to reduce. Because it is their domain. I will not go what is the license.
2017. We are only on the qualification that
that is why the
bar created by the qualification.
We are also not interfering the qualification. Only we are interfering
the applicability of the from a
prospectivity of the operation.
Exactly.
Nothing else.
Effect of malice.
Yes, my lord is in the different.
Grateful.
Mr. P.K. Deputy Solicitor General of India, who is appearing for the Archaeological Survey of India.
Along with Chandrakant Pradhan, Senior Panel Counsel.
Mr. Chandrakant Pradhan, Counsel, to file a short affidavit referring to the provisions under which the maximum number of licenses that can be granted by the Archaeological Survey of India for the Sun Temple premises has been determined. Stopping the notice under Annexure 7 to the WPC, to the writ petition being WPC 11595 of 2023, it appears that on earlier occasion, the number was 68 as per extent policy. Mr. Paridan, its DSGI is requested to produce the policies which regulates the maximum number of license for the Konark premises. On the next day, the matter will be heard on merit for disposal, and accordingly, if any additional affidavit is intended to file by any of the parties, shall be so filed by 24th of August after supplying copy to the other parties. Just record the name. There are some petitions and everything combined or on the names of the lawyers.
Since my lords have opined that this order will be confined to the petitioner, now so many writ petitions will be filed.
Yes. No, these writ petitions, sorry. Those are filed already. That these are writ petitions come and then you see what you do.
Malad, for the interest of justice, one humble submission, Malad.
Yes.
Malad, that 110 numbers they are allowed. We are not allowed. I may pray that till 30.
No.
I may be accounted to.
That is what Mr. Mudali is indicated. That so many other writ petitions will be filed.
We'll also give the other repeats and numbers.
No.
And showing pendency, my lord, again, they will create problem. Lordship may clarify the situation. You also kindly see what they are doing. 250
We have
people.
not passed any order as yet, because there should be a manageable number.
Yes.
And we also know what mechanism can be followed for the filtering the things.
Yes.
We can also say that you also give the camera.
No.
What camera can be used? Then 50% of these people will go run away from the place.
They have, in fact, they have to.
That is we can say that your equipments also to be shown. Camera, I mean.
The equipments are available, might not know New Delhi is on the market.
No, not equipment, of the certain specification.
That is available in
This officer is saying there, suppose tourist will be 20, the camera will be 50.
300 now. 300 now.
The tourist number is very small.
That it should, we will not go there, because if they do not
say SIS taking
Not comfortable to
precautionary step as regard to the photography, as regard to this assisting to help the tourist, the photographer should give the proper assistance to the persons that are interested to take photograph. Their concern.
their number is increased. Now then there will be complaint will coming to this Orissa government tourist department that the photographers are harassing us in the name of taking the photographs.
Yes.
That will come in future.
This is unauthorized license.
This, we have seen in some
Obstruction has started. Obstruction has started.
That is why we just want to this impasse should not be there. They are not allowing anyone to enter into the place. No photographer. Those who are enjoying the license, they are also not allowed.
Yes, exactly.
That cannot be.
That is the present scenario.
We have met few officers smile on. Because of few amount of persons.
That we understand.
My last can be helpful also to these things.
Yes, that is why the SI can also request these local administrations.
They have requested, that letter.
Nothing has been. We have my last I think
Central force should be deployed. Central force should be deployed, like other monuments. Now only some few security guards are being deployed. Therefore, they have stated that 250 people are obstructing. To the security guard, that is their letter, own letter.
All right.
Please deploy CRPF.
All right, we'll take care of all these things at this stage.
Item number 36.
36. At 36, 5th September. Well, similar matters will also 5th to 5th September. 36, 5th September.
This from 5th September, when the analogous matter is set. Then
Item number 39.
At 39, let's call this matter on 18th August. On that rehabilitation matter, will also
39.
I'm appearing for respondent one. Item number 39, my lord.
18th August, sir, on 18th August. 18th August.
Item number 40. May I please, my lords? NCERT, National Council for Educational Research and Training, my lord, usually conducts a national talent search examination every year. For that, two stages are there. First stage is conducted by CERT by the state. Second stage is conducted by the NCERT. And the second stage, two examinations are there. One is MTS, Mental Ability Test. The other one is SAT, Scholastic Aptitude Test. One is required to acquire 40% of the mark for being declared qualified to have the award. That is, in terms of rupees, the award is given. To qualify, 40% is required. My lord, before the Honorable Single Judge, the respondent who filed the writ application, he didn't score 40%, but a fraction less than 39 point something. So, by the method of rounding off, that has been considered to be 40%. He has been declared qualified. Against that, I am before your lordship. On 2-3 occasions, I have got judgments of the Honorable Supreme Court, also of our High Court, that rounding up is not permissible everywhere. Once it is prescribed in the statute or in the regulation, then it is permissible, otherwise not. In our case, another difficulty is total number award is fixed. So once it is rounded off, means it will surpass that number. Total number is 2,000. Earlier it was less, subsequent years it was enhanced. So this year, we are concerned with the case, this year the total number of awards was 2,000. So by this way, we are not in a position to give.
You mean to say that if the rounding off is permitted,
yes, ma'am,
that will cross the
2,000.
No purpose will be served.
Yes, ma'am. If your lordship.
Lordship, before going to the merit, Lordship, I think there's a combination of delay application.
424 days. We have seen it.
Oh, sorry. I should have addressed your lordship on that question first.
They have not explained it. I think, Lordship, it was to be heard on for condemnation or delay first. If they want to go on merit, Lordship, then a date may be fixed. My learned senior will assist you, Lordship. He's in accommodation today.
So
the delay has not been
known on that. In 5859 of 2023. There is an application for continuing the delay of 423 days in filing the intercourt appeal from the judgment dated 7/10/2021. I think earlier notice was issued.
Notice was issued.
2-3.
Notice was issued.
You have not filed any objection.
So Lordship will file an objection to that effect, Lordship.
And on the
Lordship, in the interim application, they mentioned that the delay is for 142 days.
No, according to the stamp reporter, it is 423 days.
Yes, that's right, madam.
So, since you have not filed the objection, what to do?
So we pay for some time to file objection to the condemnation delay application.
But it was last order was on 2/3/2023.
Then
when you received the notice?
I think the petitioner is the notice. Not need to take instruction on it.
You received sometime in 7/8/2023. Always, because 7/8 is the date of receipt of notice according to the registry. So we are fixing the matter on 21st of September. List on 21st September 2023. Meanwhile, the opposite party. This is item number 40.
I also. I filed another interim application for stay on the last occasion when the matter was heard and notice was issued. That time, no contempt application was filed. That is why the unknown court.
Lordship, in this regard, Your Lordship, I beg to submit. When contempt was filed on 24th August 2022.
This opposite party may file their objection if any. Stop. Just below that, there is another application. Put that number. 859. There is an application for suspending the operation of the impugned, suspending the operation of the impugned order. The impugned judgment dated 17/2021. Past instances. Stop. You don't proceed with this. You say that this matter has been fixed and such. If you go on the both sides, you will pass the stay order. Otherwise, no, given that you have undertook before the court, you will not press that contempt proceeding. You filed the Bhugalatnama?
Yes, Your Lordship. My name is S.S. Tripathi, my lord.
I know. I'm asking simply as a query. Yes. Mr. S.S. Tripathi, that counsel appearing for the opposite party has stated that they would not raise the contempt proceeding.
It has already been disposed of, my lord.
What?
The contempt was filed, it was been disposed of by order at 21st November 2022.
As I stated that the contempt proceeding has already been disposed of by the order dated
21st November 2022, 21/11/2022.
As such, we do not find. We do not think that there is any situation to cause an order staying the further operation of the judgment. As the appeal itself is delayed by more than 1 year.
Right.
All right.
Keep your place, my lord.
Your Lordship is calling it on
21st of September.
Matter number 41.
Even there, he appeal. I'm challenging common judgment.
My appearing for respondent number 4, Lordship. May I pray for tomorrow, Lordship? There is difficulty today.
Very difficult.
The entire ground of challenge, my lord. Do judgment passed on single judge same day, relying one circular of the government, and on single judge allow one case and dismiss my case. On this very same day, judgment pronounced in both the cases. I have also enclosed in the appeal memo.
By the same single judge.
Same day judgment pronounced, relying one government circular, one date of allow. That is annexed. I have enclosed that in the appeal memo, and the present case has been dismissed. That is annexed 6 and 7. 7 is the impugn judgment. 6 is the another judgment which is passed on the same day by the very same single judge. All I also keep it tomorrow because
it's very difficult. Tomorrow's board cannot be because it is a publication is necessary that already we can take up day after tomorrow. Let us see what happens. This day after tomorrow, the request made by what is your name? I forgot.
Lordship, Pragya
Manthi, yeah.
Respond.
Yeah, please. Mr. Das, S.K. Das.
I'm on Mr. Das.
What is your name?
My name is Sangram Jena.
Yes. Mr. S. General and Counsel appears on instruction of Mr. S.K. Das and Counsel for the appellant. All right. Day after tomorrow, about 3 appeals.
Item 42.
May I proceed?
Yes.
So, this is a PIL for seeking a direction for removal of enforcement over the water bodies, Your Lordship. On my representation, there is an inquiry conducted by the IRI, and the inquiry report is at Mr. for Your Lordship, page 31, Your Lordship. Chandaka Bhubaneswar, Your Lordship.
We have one of Cuttack, I think that is different.
That is in Cuttack. Yesterday it was this.
Report for the same day so that it be easy, or this is totally different?
In this case, your Lordship has directed me to obtain instruction and file counter affidavit. I have asked them to send the Parvai's comments, so 2 more weeks may be required to file.
2 more days.
2 more weeks.
When is that case posted to?
That is 4th September, I think. 4th September.
So this will come also on 4th September. Let them file the affidavit.
Yes, sir.
At the request of.
I have already filed the requisites in respect of the private opposite party number 3. Your Lordship.
Yes, that would also, there is a private respondent. He is to appear and.
I have already filed the requisite since 18/5/2023.
For opposite party 4.
Yes, sir. Open number 4. Your Lordship.
His service is complete.
But appearance was.
At the request of Mr. D.K. Mohantil and additional government advocate, that the matter will be listed on 4th September 2023. In the meanwhile, the state opposite parties number 1 to 3 shall file their affidavit in terms of the Order dated 15/5/2023, right? 15/5 order.
Yes, Your Worship. 15/5.
Stop. Despite due notice from the court, none appears to the respondent of court, the matter is taken up. Ms. Subhalakshmi Devi, London Council, has appeared for the petition and order.
Yes.
Table 43.
Not your Worship.
Yeah. She remembers that matter, RI office building to be constructed either at Borkul or at Balikuda. Tender is Borkul. Our grievance is, it should be Borkul, not in Balikuda. They have filed counter in the meantime, saying that this is not convenient. I will kindly appreciate the map they have appended, which will make it clear which
How
is
to
more.
to determine which is more this?
Map will itself show.
No, who are we to decide it? NAP doesn't help us in any manner in such decision.
No, they are deviating from the tender. That is why your worship may consider it.
The reason that we like to know.
The reason is tender is for better.
Advance is only that you floated the tender for the one place, all of a sudden you have changed that. And it is basically now is turning into a fight between the two villages. You are appealing for one.
I'm sorry, that today I got the instruction to appear on behalf of some villagers of that particular place wherein the construction is going over.
No, that is why you are actually contemplating. Why the people are not coming to fight? There is an opportunity.
Today only I have got the instruction in matter for me to one day I can file intervention because they have not added me in their party. Definitely, that is their choice. But I want to be intervener. If matter permits one day, I can file.
Yes.
Construction should be stopped. No. In the meantime, they are going on in warfighting basis.
Let them build
Construction is going on.
for something else.
For the benefit of construction is in larger public interest.
Yes.
If not this building, it can be from any other building.
If you will see the counter, and that is the honest. In that map, Balikuda, I want Justice Ratno, Balikuda is in the last. Whereas Borkul is in the middle. Borkul is connected to so many villages. Villages of other villages will be more benefited.
I will clarify all this as well. Although I am not a party, I cannot have my speak. Absolutely, there is no land available in that particular place. That's why it has been. And the flexible are adjacent. This distance is less than some 500 meters.
My lord, can you see my paragraph
that 8? Paragraph 8 just was identified with regard to the paragraphs 4 and 5, 4, 5 and 6. This is the paragraph.
Yes, my lord. The name is Revenue Inspector Circle Office, Badakul. But the construction is at village Ashram Balikuda.
No land is available. That is the reason for the form will be valid on.
After that, you have not filed any response affidavit. After the reply, you have not filed any response affidavit.
Rejoinder. No rejoinder.
I'm just making a prayer. I was about to make a prayer that I will seek 7 days time to file a rejoinder.
That's good.
Good, he will also file short.
Let the matter be listed on 21st of August 2023.
Construction.
No, sorry. You will not stop any construction. You don't know how the villagers get one construction from the administration.
No, they are going against the tender.
No, funds.
There is cause we take the disciplinary action against the officers responsible for that. We find these they have to tweak with the government policy.
That will again take us to police station. But
you are not required to go. When the court order will be, you are not to go to the police station. Nobody is going to police station. Don't be excessively anxious for anything.
There is a village meeting, so many annexes have been
so many things, including declare someone as a witch also.
Very recently, there is also a paper publication concerning this particular fact.
Because you filed, that is why I am asking you, you have not filed any rejoinder.
Because the counter was received only 2 days back.
That is why file it, or otherwise you can continue. If you say to us that you will not file the rejoinder on the basis of the government statement, we will pass the order. And first, meanwhile, the petitioner may also file the rejoinder if any. Yes, yes.
When the matter was heard, they also said that he decided
Change the mind.
he shouldn't take it action. That's then the paper will be extended. She didn't pass away.
We have secured formally. File it. National Government Advocate has appeared for the. Yes. We pass the further 21st.
Item 44.
But I mean, my lord, in the opinion that noting that came, the notice was returned from opinion number 4. I mean, for him to take fresh notice in correct address.
You are not audible properly. Voice is breaking.
I may be permitted to take notice, fresh notice on opinion number 4, my lord, with correct address.
All right.
PIL and no such address.
Notice written from opinion number 4 saying that no absent opinion, no address is available in the village.
No, that is not the noting. Noting is no such address.
No such address. So I take correct address.
Council.
Correct address.
You have filed the vigilance memo?
Within 7 days, man.
Petitioner. Huh?
He's for the petitioner.
You are for the petitioner on the opposite party number 4.
Petitioner.
I am for opinion number. I am for petitioner to take fresh notice, man. On opinion number 4.
Oh, all right. Mr. P. Azariel and council appearing to the petitioner asked for a short accommodation for taking fresh step on opposite party number 4. Yes, that the matter be listed on 21st of September 2023. The petitioner shall take some fresh steps by 18th of August 2023. It is made absolutely clear if no step is taken, no further accommodation for the same purpose is made and consequential order will be passed.
Fine.
For hearing item 45.
Item 45, my lord, I may be to VC.
Yes.
My lord, Mr. D.
I also apologize for appearing on VC, my lords. As I'm not there.
My lord, Mr. Mishra is in the panel and he has entrusted the brief to me, my lord. I was not able to collect the paperwork. For 2 weeks, I'll come prepared and I'll make arrangements to collect the paper.
It is a 2006 matter.
My lord,
We'll take up this matter.
Once they are on bail, they don't.
2003.
We'll take up the matter on 14th of August.
I humbly pray.
No humble pray. 2006 to this, 20 years almost.
20 years
Nothing. We are giving the adjournment because we are otherwise will be in difficulty. Come on 14th August, completely prepared.
My lordship, can it be on 17th if I may?
No, nothing. 14th August you come.
Obliged.
At the request of you are Mr. Mishra?
Mr. Prabha Behra.
Mr. B. Behra?
P.
Behra on council. That the matter be listed on 14th August 2023 for hearing. It is made absolutely clear no further accommodation will be made in this matter. This appeal is pending since 2006. Stop. MSS Panaik, an additional government advocate, has appeared for the state. Following the next matter.
Item 46.
46.
Yes.
My lord, paper book, you have not received the paper book. I also don't see the appellant's law.
Current status report not received. I mean, paper book is supplied at your office or somebody goes from your office to collect it?
We have to collect it, madam.
Paper book is ready, collected.
Yes, Lord, should I grant me a short date?
21st of August.
Oh, yes.
At the request of NSS Patnaik and Additional Government Advocate, the matter will be listed on 21st August 2023.
Listed on 5/7.
I may be pardoned for interrupting. I apologize for interrupting, my lords. In item 45, I do not know about the status of the appellant, my lord. So,
no, you are not required. You argued before us.
It was listed last month, Mr. Asked for time before this matter had been listed 1 month back.
Paperwork shall be collected by Ms. Patnaik, as she has stated that her office could not collect the paper book. So no further accommodation will be made in this matter. Who is appearing for this appellant here?
Nobody.
None appears for the appellant, and the matter is taken up.
I think on legal aid somebody had.
Item 47.
No, there's someone is there.
Yes. This for secretary legal aid
No,
had been asked to assign a HK Malik.
HK now. Only Colonial Council has been engaged as a legal aid counsel.
There is no appeal.
A copy of this order is served to Mr. Malik through the Secretary High Court Legal Services Committee. All right. Next.
Item 47. Yeah, item 47 is a connected appeal. I am for second matter. CRLA 195/2014.
Connected with which matter?
407 matter.
Some status report.
Connected appeals are there. Ms. Patnaik.
Item 46.
You take instruction from the jail authority. What is the status of this appellant?
In 46, my lord.
Yes.
45 and 46 both.
Yes.
Not addition. She will take no addition.
No, already one misread one.
All right, let us see what happened to that. Because by the next date, we want to the status of the appellant. All right, this earlier order, Ms. Patnaik is directed to collect the status of the appellant from the concerned jail authority.
Yes. 47. Item number 47, there are two appeals matter there. I am for second item matter. CRLA 195/2014.
Yes, argue. Your appeal, you argue.
I am not taking paper book matter.
Huh?
Not taken food.
Paper book not yet made EC matter.
What?
What?
Paper book not yet collected from list.
Paper book.
He has not received the paper book.
So they still will go to your office to.
No. I will go to take the
List on 21st of August 2023 at the year, Mr.
What is your name, please?
Rajiv Mishra.
What, Mishra?
Rajiv. You are there? RB Mishra.
Yes.
The request of Mr. RB Mishra and council appearing for the appellant. It is criminal appeal. Or second appeal. Huh? Ms. Patnaik, are you appearing in this?
I am appearing close.
Mr. Kakkar.
I am.
Oh, yes, Mr. Kutukias appears for the state. What happened in this matter? You are not appearing for the.
No, my lord. Criminal appeal 407/2014. I am not.
Are they on bail or?
I am on bail. He is not in bail. Criminal appeal 407/14 is not bail. In my client appellant is bail.
Bail 407. That means 9 years. No.
Someone is here. Can they? 10 years here.
Sorry?
The courtroom, someone is there who is having the practice of 10 years.
Checking.
Mr. Kotukia, the counsel here, was in the practice of 10 years in some criminal background?
Nobody I can't see.
Senior counsel Mr. Roth is there.
Mr. Roth will request you.
Yes, ma'am.
Someone is languishing in jail, his appeal is not being taken, nobody is taking care. You have fixed the matter on 21st. Yes. We still supply you a paper book within 3, 4, 5 days. Okay?
Right.
We have requested Mr. P.K. Rathan, senior counsel,
407.
to appear for the appellant As long as no representation from the appellant here and he is languishing in the jail. Stop list is directed to supply his full set of the paperwork to Mr. Roth within next Monday by 14th of August 2023. Stop matter is fixed on 21st of August. All right. Mr. Kotukia appears for this page. All right.
Item number 48.
Lordship, item number 40, Lordship, in the second writ petition, my lord. Lordship, Mr. Pitambar Achay leading me in this matter, and this is an accommodation, Lordship. May I any day next week?
This is a public interest litigation.
Yes, my lord. Yes, my lord.
My lord, I am appearing for the corporation. The challenge is, my lord, to a very peculiar provision. The petitioner claims that they are paying the taxes, but there is after the NRA, this national Jawaharlal Nehru Urban Renewal Mission Program, a rule came in 2015 where the corporation is empowered to charge users fee. So now the users fee they are bungling with the taxation. The users fee is a separate chapter.
No, it's all
and
right.
that is why.
No, Mr. The three parties, that is, the scenario is not available today. Mr.
Last 2 dates, the last 2 orders are like that.
All right. This is the last chance, no accommodation. It will be taken on 14th of August.
My lord, can it be 16?
Mr. Tripathi, this is the last opportunity that we are granting to you. In future, at least a council of your standing will not be allowed to seek adjournment. Come prepared.
Can it be?
Otherwise, will be passed. What is the?
Can it be, my lord, 16? 16, my lord. 16.
All right. For the request by Mr. S.S. Tripathi and Council appearing for the petition. This is in 11885 of 2016. Right, in the first case, you are not there.
No, my lord.
My lord, first I am for the on behalf of Mr. Ranjan Kumar Rao. My lord, Mr. Ranjan Kumar Rao never is hospitalized. So
it will be taken up.
Both the matters similar. Both the matters similar.
All right, yes. 16th of August, Mr. N. Mahapathru and Council has appeared. You are for the appearing to the corporation, I believe.
Corporation, opposite party number.
Corporation opposite. In view of the order passed in WPC 11885/2016 in the other matter, there is this matter on 16th August 2020. Right. There shall be no accommodation in the next day. It is also applied in your case also.
Interim order to continue, my lord.
Interim order is passed and you shall continue.
Deeply obliged.
Item number
40. I am telling you,
Your lordship.
tax, free, then optional, surcharge. These are the 3 different characters operates in the different domain. No, fee. I think this is based on the principle of quid pro quo. I will give you something, you will give me something. Right? The fee principle is based on that only.
And that is in fact introduced. That was introduced in 2015 throughout the
country. If you do not like this service, nobody will compel you to take it. But if you take, you have to pay something.
Your lordship, our claim in this matter was that it's a part of the holding tax. Your lordship will address.
If they are making a part of holding tax, that's wrong. That you can distinguish. Because only he provides you service. Because I cannot take your service.
My lord, the holding tax service is one part. There are some additional services in person to the notification 2015 for which user charges.
All right, let us see what service they provide. But when you talk about a service, a consumer or this customers, they are at liberty to not to take your service also.
Suppose where is not.
All right.
They are having the service. The service is provided. They are having the service.
Something that you may not, there is some element also there. Suppose the service system that is a serious issue.
My lord, these user charges are applicable to the places where the restaurant, hotels, hospitals, this is not meant for the slums. Slums are exempted from.
All right. Let us see.
Item 49.
Yes.
I appear for the petitioner in item number 49, Your Lordship.
Yes.
Your Lordship, if to introduce the controversy in the matter, Your Lordship, May I take your lordship to the impugned judgment, and your lordship can come to page 30 of the writ appeal, and the controversy is in fact summarized in this para at page 30.
Of your, this is a writ appeal?
Writ appeal.
The writ appeal against the single judge order. Mr. Rao is the defendant, right?
You are there?
Yes, Lordship. I mean, Mr. Garia.
No, we are asking opposite party. Mr. Rao is there for that.
I am appearing for the bank.
So, your lordship, if I can draw your lordship's attention, this is page 30, internal page 5 of the impugned judgment. And if I may read your lordship, as per the policy, a candidate must secure 35% marks in the interview, otherwise he shall be treated ineligible for promotion. In the instant case, the petitioner secured less than 35% in the interview, and hence he was treated.
No, he may not have attached it.
Have you attached the judgment with your writ appeal?
Yes, your lordship.
Yes, Lordship. All right. All right.
Specifically indexed to the IN order second. The problem.
There is no page marking. Just ask this history. Are we going to page mark everything?
Internal page 5, your lordship.
He's not given any index, so they have not paid.
Internal page
5, your lordship.
5. Yes. Yes.
Internal page 5, top of it. As per the policy, a candidate must secure 35% marks in the interview, otherwise he shall be treated ineligible for promotion. In the instant case, the petitioner secured less than 35% in the interview, and hence he was treated as ineligible for promotion, and finally he was not promoted. In the process of promotion, there were candidates who got more marks than that of the petitioner, but still they were not selected because they could not get the minimum marks specified either in the written examination or in the interview. Further, your lordship, page 30, I would draw your lordship's attention to page 7, internal page 7 of this judgment, bottom.
Yes.
Your lordship, it is the contentions of the bank are noted that it is respectfully submitted that the petitioner could not be selected in the promotion even though he secured more marks than the minimum cutoff, because as per policy a candidate must secure minimum of 35% marks in the interview, otherwise he shall be treated ineligible for promotion. In the instant case, the petitioner secured less than 35% in interview, and hence he was treated as ineligible for promotion, and finally he was not promoted.
Yes.
So, your lordship, these two paras I referred to introduce the issue in the matter, which is that though the petitioner participated in the selection process and he had otherwise secured more marks even than the candidates who were eventually promoted, he was not promoted because he did not have 35% marks in the interview.
Yes.
And therefore, your lordship, I will show your lordship that this 35% marks, your lordship, I have filed my written submission. I hope this written
written submission. Yes.
Yes, your lordship.
You please take note of already his submission. You have to make the submission right now.
Now, your lordship, I will draw your lordship's attention to the reason given by the bank for not selecting the petitioner and why this requirement comes in the way of the petitioner. This is para 9 of my written submission. para 9 of my written submission.
That point you have already covered. Go forward.
No. Till now I have only pointed out that they have not selected.
That is the reason of your rejection in the selection process. Are you challenging the cutoff mark 35%, or are you saying that the imposition of the 35% mark is the cutoff on the basis of review is not sustainable?
They cannot do it. This is what I'm.
That comes straight to that point, Land Council.
Yes.
You are showing the same point on 3 parts in the written argument. We have already seen the bank stand.
Your Lordship.
Yes. What is the ground that cannot do that?
Your Lordship, this they say that is done in accordance with bank circular dated 31/3/2012. So I will show Your Lordship this bank circular. This is annexure A to the counter affidavit.
Yes.
Yes. Annexure A to the it is annexure A to the counter affidavit, Your Lordship.
Then is the writ petition records.
Yes, Your Lordship, writ petition records.
Is come paragraph?
Your Lordship, page 59.
59.
Of page 59 of the running page of the writ petition. And this is annexure A.
Is
annexure A. This is the circular that Your Lordship they rely upon. Now, if I may read this circular, Your Lordship, this is a circular policy for promotion of officers GMGS to MMGS 1 to MMGS 2, 2 to 3 and so on. And please refer circular number 308 reference 23/2012 communicating the revised government guidelines for promotion of officers for one grade to another grade as adopted by the board in the meeting held on 2nd February 2012. While the guidelines of the government will form part of the policy, other provisions such as appointment of vacancy between channels, allocation of marks, etc., which have not been specifically prescribed by the government, were approved by the board of directors of the bank in the meeting held on 17/3/2012 for promotion of officers from grade 1 to 2, 2 to 3 and 3 to 4 under regulation 17 of the Andhra Bank Officers Service Regulations. So what I draw from this para, Your Lordship, that government guidelines will form part of the policy.
No, Land Council, you come straight to the normal / security channel, and then there is a fast and merit and fast track channel also that you see. There is clearly stated merit and fast track 65%, normal security channel 35%. You are coming to normal and security seniority channel. So this is the para 2 of the circular dated 31st of March 2012. Is very categorical and expressive.
Yeah, Lordship. I'm in merit and fast track channel. This percentage is about allocation of seats, not about the allocation of marks.
Now there you have to get the 65%.
No. This 35-65% is out of 100 vacancies, 65% under.
Oh, that's right.
Okay. Yes.
Allocation of vacancies only. This
allocation of vacancies only, Your Lordship.
Okay.
Your Lordship. Now the condition which is the bone of contention in this case, Your Lordship can see at page 61, para 7.
Okay.
This is the condition which has been introduced by the bank by way of a circular. This is a bank circular.
Yes.
And this circular itself says that the guidelines of the government will form part of the policy, and circular 7 and para 7 of the circular, they have introduced an additional condition of securing 35% marks in the interview. They are saying government has provided a policy for promotion, how it is to be done, everything government has provided. And we are under an obligation to comply with the government directions.
So according to you, the source of this imposing 35% comes from the government norms.
Does not come from the government.
Does not.
Contrary to the government.
Just a pause, Mr. This what is the source of this 35% cutting?
Sir, Lordship, I am appearing along with Mr. Gari, opposite party, Mr. Gari.
Yes, Mr. Rao.
Yes. You want to source the either in provided or you are just adopting the government policy?
That is, Millard, in the judgment is very clearly dealt with. Your Lordship, kindly see paragraph 6 and 7.
Wow. Have you counter-refuted?
In the judgment itself, all the points my lieutenant which has raised.
No, don't go to the what is the affidavit you have taken this plan?
You have clear stand you have taken in the counter. That is, Millard, your Lordship will get it. Page 100. Millard, para page 2 of the counter, page 102, Millard, page 102. Counter para 2.
Yes.
Para 4, you will kindly see counter. Millard, before that, Millard, may I submit one thing, Millard? This circular was issued in 2006. Without any objection, he appeared in the test. He has not qualified.
Understood, but we want to see how this 35% has come.
Yes, I have clearly explained, paragraph 4, your Lordship, kindly see, page 102, writ application.
Writ application?
And that was also dealt with you.
Writ application or your counter affidavit? Because you never counter affidavit.
Counter to rejoinder.
Counter to.
So page what? Annex?
Yeah, going to the bank opposite party.
Yes, I am looking for the bank opposite party.
Counter to rejoinder.
I have found the rejoinder, Millard. He has filed rejoinder, to counter file. Elaborately, it is discussed how this.
Counter to rejoinder.
Counter to rejoinder. Yes. Millard, that is running page 102.
104, your counter to rejoinder. So which paragraph?
It starts from page 101.
No, give the paragraph number.
Paragraph 4, Millard, next page.
Okay.
Paragraph 4.
Paragraph 4. It is contains. It is very elaborately explained.
Yes.
The circular earlier, Millard. It is contention of the petitioner that the promotion policy dated 31/3/2012. The respondent bank is based on the government's guidelines on 5/12/2011, which was superseded by the government's guideline dated 14/3/2012. And thus the promotion policy of the respondent bank as novel laid by. The respondent bank refutes such contention and submits that as per Regulation 17 of the Andhra Bank Officers Regulation 1982, promotion to all grades officer in the rank is made in accordance with the policy laid down by the board from time to time. Having regard to the guidelines of the government, if any during the year 2005,
Ministry of Finance, Government of India had formulated certain guidelines relating to managerial autonomy to public sector banks and communicated the guidelines by DO number so-and-so date 22/2/2005, wherein public sector banks were permitted to take their own decision with the approval of their board on matters relating to human resources, including promotion. The copy of the DO is annexed here with Annexure A. As per the DO, the bank is free to formulate its policy promotion to the HR issues. The Department of Financial Services, Ministry of Finance, Government of India, by their letter dated 5th December 2011, had issued guidelines on the matter of promotion. In supervision of all the earlier guidelines, with direction to the same should be adopted uniformly by public sector banks after approval of their respective boards. Copy of the guidelines of the government dated 5/12/2011 are annexed to Annexure B. After receipt of the guidelines, they were approved by the respondent bank's board, while its resolution dated number 22 dated 2/2012. A copy of the resolution is annexed to Annexure C. Since the government guidelines dated 5/12/2011 have not specified with regard to the appointment of vacancy between channels, allocation of mask, etc., respondent bank, after discussing with the majority officers union, All India Andhra Bank Officers Federation, reached an understanding to modify the policy of the promotion. A note affecting modification was placed before the board for approval of, and finally a resolution number 39 dated 17/3/2012 was passed in this regard. A copy of the resolution is annexed herewith as Annexure. After the resolution was passed, a circular dated 31/3/2012, the present circular which was issued from 2016, knowing about the circular, he has appeared and not qualified. Not only he, persons above him, about 100 persons also not qualified.
They've got more marks.
Yes.
They've got more marks, but they also did not qualify in the
Qualified. They are also not qualified. They are not qualified parties. So next year, 2017, same circular, he has appeared and not qualified. A number of persons above him also not qualified. That is Annexure I. I have given details. How many persons are appeared and qualified. Law is now settled that once he has appeared, knowing the conditions available and are not qualified, he is stopped to raise all these points. There are Millard, I have given all the decisions, so Lordship also dealt with in the judgment, all the decisions which I have cited. And next Millard, not only that, after resolution was passed in circular number 663 dated 31/3/2000 was passed, circulated among the staff members, which is still in force. Even now also, the examinations are conducted on that basis. A copy of the same is annexed herewith as Annexure E. The Government of India issued press guidelines dated 14/3/22 in supervision of the all earlier guidelines dated 5/12/2011. In this, it is contended by the petitioner that circular number 444 of the respondent bank has no legal binding in view of the 14/3/2012 Annexure F guidelines of government. The respondent bank refutes which contention that the bank is vested with the power of formulate its own promotion policy as per government letter dated 22/2/2005. As per the guidelines, the bank formulated promotion policy dated 31/3/2012. Government guidelines dated 14/3/2000 were adopted by the bank, while the board note dated 29/3/2012, which was passed by resolution number 4 dated 7/5/2012. Thereafter, a copy of the resolution is annexed with Annexure G. The bank is following the guidelines of the government whenever there is a change in the guidelines. At no point of time the respondent bank has deviated any of the guidelines issued by the government. The petitioner participated in promotion process held in the year 2016, 2017, 2018. The guidelines framed in the year
35 is prescribed. That 35%.
explained.
No, explain. No, where is that 35
Yes.
for that interview in this resolution 17/3/2012?
20. And that is also clearly, next also it is explained. And I have also given the details of how many persons appeared, how many applications received,
Not paper.
and persons.
We are little confused about one point. That point is that by which circular that you have adopted this 35%. You says that in this 31/3/2012 circular, it clearly mentioned that it will be the 35%.
Yes.
What is that circular?
That means that annexure B that is given there also, that is detailed given.
That is
annexure A Miller, that is the circular. That is the circular Miller.
No, you are saying annexure E is based on annexure D.
Yes.
So annexure D, that 35% just point out because different.
I have pointing out that is.
That's specific way to point out.
Annexure D of.
Or D of their reply to rejoinder. So that is at page 237. Scan copy 237.
This is 1/1/2018 circular.
Annexure A, annexure A, that is circular Miller, page 59.
Reply to rejoinder.
Page 59 Miller.
Go to page 230.
And your lordship kindly see the 35% your lordship will get it at page
32.
Page 17 of the counter, coming page 59, annexure A. Next page, Miller, your promotion to MMGS 223. Interview, Miller, 30, that is 24 out of 100.
The DO letter, you said that it is based on some resolution. So that we are seeing where it is pointed out to us.
That I have explained Miller elaborately now.
You have given that annexure. From that annexure, please show us.
Yes, annexure B, Miller, that annexure A. Annexure A is the circular we have issued.
That is the DO letter.
Yes, our that circular.
Circular is 31/3.
Yeah.
You explain, you read out to us that.
I have explained how this circular was passed. Now I place it paragraph 4. Is objections raised and I have clarified.
Yes.
And that is given on that. Even assuming Miller, now apart from that, this circular was issued. Basis of this circular, he has appeared to examination.
And we have understood.
And after examination also, and he was not qualified in 2016. No objection raised. Next year also same. Because now your lordship kindly see, I have exactly similar point was arose in 1995 Supreme Court, 2008 Supreme Court, 98 Supreme Court. And I given all the decisions available, your lordship kindly see.
You see this, you are just relying on the estoppel by conduct. That principle.
That is estoppel based conduct. Apart from that, Miller, that is one aspect. Even how the managerial autonomy was given, and it has to be placed before the board, and all India the unions.
We all understand that All India Union came to an understanding with you, and accordingly we have implemented it.
Yes.
Right. This part is already. He has stated this was not known to him before participation.
Yes.
Number one. Number two is that because he's a whistleblower, that you are making the witch hunt and to stop his promotion.
Yes.
That is the number two. This is an allegation of malice. Right. That will differently because on the terms of the EP Royal Press of 1974 Supreme Court, we have to decide how he has pleaded things, how he has proved the things.
All these things are available to him now, after once he has participated with eyes open.
No, this is not like a geometric formula. Sorry. The estoppel cannot be a geometric formula. Suppose I do not know that you have changed the rule. This after.
No, there is no question of I have indicated paragraph 4 detail.
Paragraph 4 detail you have indicated saying it is based on this document. So we are asking, please point out from that document.
That document will have that is circular and annexure that is promotion to MM2 to MM3. That is which the exam the APL.
Annexure of which
For entry 24 marks is given.
Oh, there is the
That is also in that subsequent paragraph I have stated that.
In paragraph you explained about the policy and
Yes, policy has given.
no, are you arguing on this managerial autonomy that I have autonomy 35%? I will propose just
that you are also filing 61, page 61. Promotion plan.
What is the document? Tell us the
annexure A to be counted. That is circular. Issued wherein it was indicated the interview 35 by a mark is there. That is 24 out of 100.
All right.
Internal page 19, page 61. You last got it. The tabular column will add first is James 1 to 2. Second is promotion to MMGS 2 to 3.
Yes.
That is his consent. And to this promotion process he was required. And interview 24 months out of 100 is required. And the marks which he has got it, I have given in the annexure I Millard. Annexure I to that Millard, your lordship kindly see how many marks he has got out of our marks.
that is not denied. That is not disputed. How much marks he has got, that is not disputed. He's just saying that 35% minimum cutoff for interview on what basis?
Page 61, cutoff marks is 24 is required out of 100. And he got it, Millard, your lordship kindly see his annexure I have given. How many marks got is he got only 6.79.
Thank you. Mr. Rao, we'll continue tomorrow. Just with the page numbers where these principles you have just adopted. This you just either check this page number. This is available. Tomorrow we'll continue. I'm listing the matter tomorrow.
Absolutely.
You just give it tomorrow. Hard in part.
I will give me that is also there.
We have seen your list of date, but we only the page number relating 35% cutoff mark.
Yes.
Only that you just separately placed before.
35 Millard, as I will give detail Millard. Now I will try to point out to your
back to the any more today. We'll hear you tomorrow. Yes. Tomorrow, This part of we have heard. This is
that is
Mr. Lokesh Kumar Gunjan.
Lordship is not appearing in person. Lordship is not appearing in person. Mr. Galia is appearing in the Lordship. Mr. Ravindra is Galia.
Okay.
Lordship.
Oh no, Mr. Aris Galia, no?
Yes, Lordship.
Mr. Aris Galia, counsel is appearing for the appellant. Writ petitioner.
It is not there on record.
No,
Wakalatnama has been filed, Your Lordship.
Not there on record, so we got confused.
49.
Wakalatnama was filed, Your Lordship.
49. Appearing for the that is the yes. W177/2022. You just tell that we will not allow one day the lawyers will allow other day this appellant will appear in person. That system will not continue here anymore.
I apologize for this.
You decide yourself. And Mr. C.A. Raul and councillors appear for the bank respondent. All right, Mr. Raul, tomorrow will continue with you. Tomorrow.
Will it be next week, Millard?
No, tomorrow. If you, at least we can provide you at 2.
Tomorrow, Millard, your lordship kindly, I will also, there it is 46 page, para 7. counter 46. Page 46.
That is what you asked you. You show the para 746. This is the document in support of the 35% of the cutoff mark. Because we are not like, we are hopping from here to there. You just give a sheet of paper to us so that we can consolidate your submission in some point.
But tomorrow is not possible. Day after Monday.
Not possible. Don't argue. We'll hear the matter tomorrow. We are asking for a give a sheet of paper. If you cannot give it, we'll continue without sheet of paper.
Can you do Monday, Millet?
No, we don't need your paper then.
Then I will point out from the paper.
Yes, point out from the papers.
Yes.
Although we will continue that you will give the reply after his hearing, okay?
Most obliged.
Ah.